Are you ready? Great. So good morning, everyone. It is almost 9 on Friday, the 13th, and we are going to have the charge conference in State versus Beard. I shared, Mr. Beard is not here. Has he said he doesn't want to be here for the charge conference? Great. So I know he's physically here. He's out in the hallway. But he is waiving his presence for the charge conference. He may walk in during the midst of it, but we will start in his absence. Ms. Primovic has said she spoke with him and he's okay being right outside the courtroom, but we've got our prosecutors here and our defense attorneys, and we're going to have on the screen in just a moment the charge. And what I'm going to do is scroll to areas where I have questions or concerns. If I pass over an area where you have a question or concern, tell me and we'll go back to it. I highlighted and struck through the areas I wanted to talk about. If I struck through what you received, it was a charge that someone had requested, and Ms. Niles, who compiled this, just wasn't sure whether that should stay in or not. And if I struck through it, it was my view that it need not be in there. My overarching philosophy is that jury charge should be simple. And as straightforward as the law permits. The law doesn't permit always very straightforward language, but there are plenty of things we could tell the jury that they don't necessarily need to know about. Just as an example, and we'll get to it, the identification charge is very long, and it includes a laundry list of what was the lighting like and how certain was the person. This isn't that kind of case. I think there needs to be a charge on identification, that it's the state's burden and that the defense doesn't need to prove someone else did the crime. But I don't think the jury needs to hear all those factors, because Mr. Beard has admitted through testimony, already admitted that he was there and he even fired his gun once. So anyway, we'll get to those one at a time. The first place I want to stop is stipulations on page 3. I'm not aware of any stipulations. I think that charge should come out. Do you agree, Ms. Ocon?
Yes, Judge.
And who's this book? Ms. Primovic?
We agree.
Great. It'll come out. Defendant's choice not to testify. I've only highlighted that. If Mr. Beard testifies, I will remove that. If he does not testify, I will leave that in. Limiting instructions. I don't think there is any evidence that has been or will be admitted for a limited purpose. It's in for any purpose the jury wants to give it. Do you agree, Ms. Ocon?
Yes, Judge.
Ms. Primovic?
I agree.
All right, that'll come out. And now we're at identification. So you will see on page 6, I struck through a large portion of the identification charge because I don't think it applies in this case. 100% the state has the burden of proof, and it bears repeating to the jury, in particular that second sentence, that it's not the defense's job to prove that it was actually Mr. Belay who shot Lee Bailey or Awet. They don't have that kind of burden. The state has to prove who committed the crimes. So I think those first 2 sentences make sense. The others, I think, are not effective or meaningful in the context of this trial. Do you agree, Ms. Ocon?
Yes, Judge.
Ms. Primovic?
Yes, sir.
All right, I'll remove that. It turns out transferred intent was in. One of you must have requested it because the second paragraph of intent that you see there on page 7 was already in there. So I didn't need to add anything. I don't believe parties to a crime apply. It applies in this case. Do you agree, Ms. Ocon?
Yes, Judge.
Ms. Primovic?
Yes, sir.
It's gone. Good character of the defendant. I think it doesn't come in. Again, Mr. Beard may testify, but it's not going to be your classic character witness. I know Mr. Beard. He doesn't have a reputation for violence. That time has passed. Well, it hasn't passed, but you've told me, Ms. Feely, that the only witness you'd be calling, if you call one, would be Mr. Beard. So I guess we could leave it in provisionally if Mr. Beard's going to talk about his good character, but I can't imagine that's how it will play out. So I expect not to include that charge. Do you agree with that, Ms. Ocon?
Yes, Judge.
Ms. Primovic? Okay, if something surprising changes, if Mr. Beard testifies, remind me and we can put it back in, but it's not another witness. So I just don't think it's the right charge anyway. Justification. It is appropriate to charge on justification, but I believe we jump straight to the second justification charge that's in this document. And the first one, justification generally, one, I don't like it, is a laundry list, and it ought to be tailored to specifically this case, which would be a subset of Section A. But otherwise, I don't think we need it. I am charging on self-defense extensively with the new improved jury charges, but I think this justification generally ought to be omitted. Do you agree, Ms. Ocom?
Yes, Judge.
Ms. Primovic?
Yeah, none of this is relevant to the allegations.
Okay. Then we get to use of force in defense of self. I'm gonna that. I struck the combat by agreement. I don't know what folks are going to argue in terms of, well, it wouldn't be the defense that would be arguing it, what the state would be arguing. They may say there's no evidence of self-defense anyway, but the argument's going to be made. State may say, well, he started it, so he provoked Mr. Belai. If Mr. Belai could be viewed as having moved first. The state could argue that Mr. Beard was committing a felony because he had his gun out, or that he was the initial aggressor. That's what BB has to say. I don't think there's any evidence about combat by agreement. So I think that fourth bullet point ought to be struck. The other three I'll leave in because I could see an argument on any of those, but I'm open to amending it. Let's focus on combat by agreement. Do you agree, Ms. Ocom, that that's not an appropriate charge to give?
Yes, Judge.
Okay. What about those other three? Are there any that you would want also removed, or you want all other three aspects of not justified in there?
I want all of them. And as we're talking about self-defense, I was going to ask, I don't know if we get to it, that the mere words is not enough to provoke deadly force, because got up there and said,
Oh, the thing about y'all killed JB or BB or, okay. If you can send me that language, not just the pattern charge number, but the language, I will look at that. But let's table that thought for a minute. Ms. Primovic, do you have any other edits you'd want to the charge that starts in the middle of page 9? It's the standard, the new standard self-defense charge. The one edit that I am proposing is taking out that combat by agreement piece.
I agree with that.
Okay. All right. When I get the language about words are not enough, we can look at that. Intoxication, voluntary intoxication. I don't think it applies. Now, I don't know what Mr. Beard said in the first trial, and I'm guessing he was drinking like everyone else, but the only person whose alcohol level we know about is the deceased, and his actions don't need any excuse here. So I don't think this makes sense, and I think it'll confuse the jury unless something happens with Mr. Beard's testimony if he testifies. So my plan is to take it out. Do you agree with that, Ms. Ocom?
Yes, Judge, unless he testifies.
Well, he may testify. That doesn't get it in. If he testifies and says, oh my gosh, I have no idea what I was so drunk. Anything I did is not my fault. It's the Sky Vodka's fault. Then this comes in. Ms. Primovic, do you agree?
I agree.
Okay. All right. That's it. Those were the edits that I had to the good proposals from both sides. Other than mere words are not enough, is there anything from the state that you want added or removed?
No, Judge.
All right, Ms. Primovic.
I'm seeing impeachment charges.
So I consolidate those. So if you go, we will go to credibility and I mean, you can impeach in a variety of ways. You can disprove it, but the second and third paragraph in credibility of witness is a consolidation of ways you can attack credibility to include impeaching. I just don't use that word because that doesn't necessarily mean something to jurors. They hear impeach and they think Donald Trump and not, oh, I shouldn't believe said. But read those two paragraphs, and if you think they're not sufficient, I'm open to it. This is pretty standard for my jury charge, so you've survived several of these when it comes to impeachment.
Slide it in there, so smooth.
It's all about consolidation. The shorter the jury charge, the better, if we aren't cutting bone or muscle. I don't think we have here. All right, do I have an email? I don't have an email yet. I don't.
Well,
The slow servers?
yeah.
Okay. Here it is.
Okay. I'm just looking to see the prior statements.
We can go back.
Thank you.
The third paragraph is about that. I'll come back to it while you're thinking through it. I need to drop in this language. Did you have anything you wanted to discuss about prior statements?
Your Honor, we would ask for the pattern of 1.31.47. You may determine whether there is evidence that a witness testified falsely about an important fact during the course of the trial as opposed to some other time before the trial. In doing so, you may make a determination whether the misstatement was because of an instant lapse in memory or an intentional attempt to deceive. You should consider all the facts and circumstances of any prior statement.
Okay.
Say 1 point what? 1.31.47. You all asked for it too. We both did.
Right. Okay. I hear that, and I believe it is legally sufficiently covered in the third paragraph of the credibility of witnesses charge on page 4. It explains to the jurors that they ought to be thinking about, well, what did someone say before versus what they said in trial? More importantly, it empowers both sides. I think it would be more so, well, I think both sides are going to be saying, for certain witnesses, you got to wonder about this in-court testimony you just heard, given these other things. So I'm going to leave it as is, but your request is noted, and your objection to my not including the language of the pattern is preserved. Let's go back to justification. And I have added, you'll see it on the screen at the bottom of the justification charge, the words alone. This is correct law, and I had forgotten about, I think everyone was surprised to hear that little bit we heard from, was it Mr. Jeffries who Kiki, right. Mr. Yimam, that came up. That's right. We had to have a sidebar about that. So that's appropriate language. And I think based on what Kiki said, and then what Ms. Russell was explaining about what that situation was. I don't think it got sussed out for the jury all that much, and appropriately so. They've learned that that was someone who was shot. The jury didn't learn directly that through Mr. Imam that someone thought that Mr. Beard or an associate was involved, but they could make that reasonable conclusion. Why else would Solo have been yelling that just before the shooting started? So any objection, Ms. Primovic, to having that language in there?
So that's a lot.
Okay. Anything else, Ms. Primovic, that you want added or removed from the charge? Okay. Ms. Ockham, the way I present the jury charge to the jury is I'll read it to them. They'll get a hard copy of what I've read, but as I'm reading it to them, there'll be on the screen a PowerPoint that goes kind of paragraph by paragraph so people could read along. I don't think we've had a trial together, so you wouldn't have seen that. I just don't want you to be surprised that there's stuff up on the screen. It's just the text of what I'm reading. All right. I will stop sharing. And how are we? Good morning, Deputy Gordon. I'm doing well. How are you? Did your house survive the storms? Good. Mine too. Although my wife made my kids go do homework in the basement, which they thought was kind of entertaining until everything passed. I hope everyone else's homes. Ms. Feely, you've got bad luck with homes. Anything happened to either of your homes?
So far, so good.
Good. All right. No trees, anything? Good. All right. How are we doing with jurors? We can start whenever they get here. We're done. We only have 4 jurors? What? Okay.
Until 9:30.
I know, no. I just I'm impressed that this wasn't a complicated jury charge. We got through it. Last trial, I'd never done hit and run. It was all new language for me. So, all right, I'm going to clean this up a little bit, but I'll stay right here until we learn for past 4. Oh, I know. We'll find out what he has to say, Deputy Gordon. Then we need to get Mr. Beard in here and talk about testifying.
Yeah, 8 so far.
8. Okay, that's double what you thought. That's good. It's more than halfway there. Mr. Beard's going to come in. We're going to get a couple things on the record, and then we'll just sit tight. Ms. Wood,
Hi, Judge.
how are you? We've been pleading out all your cases in your absence. Ms. Primovic's just out here.
She's the Oz.
Yep. Thank you for lining those up. You bet. All right. Good morning, Mr. Beard. We, if you don't mind taking your mask off, need to have that conversation that I mentioned last night about whether you want to testify or not. Are you ready to talk? All right, Mr. Beard, do you understand that you have a right to testify and that if you wish to testify, no one can prevent you? In other words, if you say yes, Ms. Primovic can't grab you and pull you out of the room and say, don't do that. It is your decision to testify. Do you understand that? Do you understand that in the same way, no one can force you to testify? Meaning if you don't want to do it, it's not like Ms. Feely can stand up and say, now we're calling Mr. Beard and Deputy Gordon's going to tug you over to the witness stand. If you don't want to testify, you have that absolute right. You understand that? Do you understand that you, in just a few moments, are the one who's going to tell me, yes, I'm testifying, or no, I'm not testifying. I won't ask your family. I'm not going to ask Ms. Feely. It's your decision that you'll communicate to me. Do you understand that? Okay. Do you understand that if you choose not to testify, I'll tell the jury during my instructions to them that they are to draw no inference or conclusion or anything harmful to you. In fact, they're not to consider in any way the fact that you did not testify. Do you understand that? Do you understand that if you choose to testify, you're going to have to answer questions from both your lawyer as well as the prosecutor? You don't just get to tell your part and then run back and say, I take the fifth. I'm not going to answer any more questions. You understand that? You'll be cross-examined by the district attorney's office. You understand? Okay. Understanding what happens if you say, I do not want to testify, and what happens if you say, I do want to testify. Do you want to testify in this trial? Got it. I find that Mr. Beard has made the election not to testify knowingly, voluntarily, and freely with a full understanding of his rights. I will tell the jury that they are not to consider in any way, shape, or form the fact that you did not testify, and it should be no part of their deliberations. I'm going to modify the jury charge a little bit more. And when we do get all our jurors here, I will ask you, Ms. Feely, if you'll be calling any witnesses or presenting any evidence, whatever the magic words will be. And it sounds like you'll say the defense rests. Because you didn't put up any evidence, there will not be a rebuttal case from the state, and I will tell the jurors about how closing arguments work. Ms. Ocom, do you plan on opening and closing or reserving all your time for the second part?
Opening and closing.
Okay, so I'll explain that to the jury, and you'll just need to be ready to go with that first part of your closing. Depending on how long people go, we may take the morning break after. I don't know, Ms. Feely, if you're giving the closing. I assume you are, because you keep giving Ms. Primovic things like jury charges and whatnot. So we may take the status hearings. We may take the morning break after Ms. Feely is done. I won't interrupt anyone's closing, so I'll just see how long the initial part of Ms. Ocom's is. But my hope would be to get through Ms. Ocom's first presentation and Ms. Feely's, then we take a break. We have a medium hard stop at noon, but I can make people wait. I have a plea to take at noon, but people can stick around. Is Riggins here? Great. So, but that can shift because all that is left to do here will be more closing. So we'll sort out those kinds of breaks, but I envision opening and defense closing, and then we'll take some pause. Ms. Ocom, any questions about anything?
No, Judge.
Ms. Feely?
Yeah.
All right. Then I'm gonna work a little more on the jury charge, and Deputy Gordon, let us know when we've got everyone here. Okay. We the double digits?
Yeah.
Cool. They've been pretty good. Was it Freiberg was late yesterday? Is she here? Oh, come on. Ms. Primovic, what was your understanding of what Ms. Hemingway was saying about offices combining?
I haven't heard that. I know that there is, as you said, a lot of things going on. I didn't know that.
I thought she had always been, not always, I thought she was a C3. I'll have to talk with Ms. Glazer. That has been my point of contact.
Maybe she applied and is part of her office staff.
I don't know. Because the moment she said, oh, my supervisor, Ms. Walker, I'm like, uh-oh, that means you and Johnson are colleagues. Yeah. It's been very frustrating.
Yeah, maybe just join, just. That's the only thing I can think of happened, because I know there's things going on, but I didn't know about any.
Yeah. Whoa. Do one of you mind standing in front of the air purifier for a second? Just trying to get this camera to, how does that, is that, I can control the camera and I inadvertently moved it, so maybe I move it. No, wherever you would stay, if you're addressing the jury, you stand right there. I just want the camera to have you right in the center, so I should move it a little more that way. Okay, excellent. Thank you so much. You're a great model. I need to get you guys a verdict form. Need to do that.
There's one.
Is it Freiberg?
No, she's here.
Ah, what are we missing?
Good times.
Okay,
I haven't,
great. Trying to remember who that is. So she. Okay. Compliance manager. That doesn't ring a bell. All right.
Brian, do you know anything about when Judge McAfee will be sworn in?
The most tentative, no, other than what I've heard tentatively is end of January is the swearing in. So the issue is getting him sworn in. We had a governor who himself had to be sworn in, check. Legislative session has just started. That's going to take up some time. But what I've heard through court admin is that the hope is end of the month.
Okay.
We're ready to turn his criminal wheel back on.
I know, I am too. I mean.
Okay.
I'm sorry, I was looking for Miss Wood. Is she still around? I heard that.
She was here briefly. We celebrated her presence. I don't know that she was sticking around.
She's covered in vet court for us.
That's fine. Okay, thank you.
Exactly.
Does that mean she's just down the hall with Glanville? So if you need her, she's just at the end of the hall.
Okay, thank you.
Yep. Are you going to be in that courtroom?
I am, I was in Judge Glanville,
Okay,
so I just transitioned, I'll be transitioning to him.
got it. SOCOM, if you'd come up and grab this, it's a proposed verdict form, you can take a look at it and share it with the defense. Thank you so much. Cool.
You ready? Yeah. Maybe two books there. It's not gonna. Yeah, it's not gonna work on the screen. It doesn't, yeah. If you had a white, if you had some kind of. Don't use the pointer. If you want to
Yeah.
point, actually point.
Yeah,
Because that
it
doesn't
doesn't
work.
work on that.
When you were doing it, it doesn't.
Oh, I just wanna see.
Never seen it.
Well, that's annoying.
It doesn't work. It never works.
You never did.
No, so don't do it.
All right. Ms. Rivers, are you ready? Okay, we're back on the record in State versus Beard. Deputy Gordon tells me all our jurors are here. Ms. Ocom, did you have a chance to look at the verdict form?
Yes, Judge.
Any issues?
No, Judge.
Ms. Primovic, verdict form okay by you?
Yes, Your Honor.
Excellent. I have a copy of the final jury charge for each side. Deputy Gordon will deliver that. Ms. Ocom, anything else before we bring the jury in?
No, Judge.
Ms. Feely, anything else? All right, when you're ready, Deputy Gordon, let's bring them in, please. We had a federal case in the Ninth Circuit where one juror participated for the first 2 days virtually because a family member was ill. The defendant agreed, later on challenged it, but so you would have had all jurors but one, and then that juror was seeing and hearing the testimony virtually. And the Ninth Circuit said that was okay.
Nothing like being here though.
Oh, I understand, but I don't know if they learned, it took forever to get a jury and they didn't want to have to pick a jury again. It was just one juror. And it wasn't deliberations. It was just the first 2 days of the trial. And the defendant agreed to it when it happened. It's kind of hard to undo that later on.
Let's see what the charge is.
Robbery. So it must have been a Hobbs Act case. And the Oregon Supreme Court has decided that all non-unanimous jury verdicts are retroactively not good. Louisiana has said if it happened in the past, too bad, so sad. Not so in Oregon. 300 people will get out because of that. It's gonna be tricky for those DAs. That's my jury news for the day.
Because I'd rather stay. Rather stay.
All around the jury. I'll be with you, brother.
Thank you, Deputy Gordon. Happy Friday the 13th, everyone. Hopefully no one has yet walked under a ladder or a black cat or whatever all those things are. We're going to get you safely through the day while you're in the courthouse, and hopefully no house of yours sustained any damage in these storms. When we stopped yesterday, you had heard Ms. Ocom say that the state rests. The lawyers and I have worked through the legal implications and the procedural things that follow the state resting. And I'm now ready to ask Ms. Feely if the defense will be presenting any evidence.
Or this time the defense rests.
All right. So ladies and gentlemen, the evidence in this case is closed. You have heard and seen and received all the evidence you're going to get. The witness testimony is in your head or in your notepads. The physical evidence will go back with you when you start your deliberations. Two things left: closing arguments and the charge that I have to give you on the law that you must apply to the facts that you find. Closing arguments are efforts by the lawyers to persuade you to decide the case in their favor. Ms. Ocom is going to get up in a moment to tell you why you ought to find Mr. Beard guilty of one or more of the offenses charged. Ms. Feely will have a chance to get up to say just the opposite, that you should find Mr. Beard not guilty because the state has failed in the following ways. Because the state has the burden of proof, they get the opportunity to open and close with closings. So Ms. Ocom is going to get up in just a moment and share with you the first part of her closing, and she'll sit down. Ms. Feely will go if she wants to. She's told me she's going to, but again, the defendant has no burden. But I suspect you'll hear from Ms. Feely, and when she's done, then Ms. Ocom will get a chance to have the final word. We'll probably have a break in between there because closings are more than just 2 minutes. But that's it. Once we're done with closings, it'll either be lunchtime, and I'll charge you after that, or I'll charge you and then you guys will do lunch. But those are the two phases left before you begin your deliberations. Reminder, what the lawyers tell you is not evidence. They are very persuasive. They're advocates. But if you remember that someone was wearing a blue shirt and one of these lawyers keeps telling you it was red, it was red, it was red, you ought not to change your mind just because the lawyer tells you that. You may, because the lawyer reminds you, oh, one person said blue, but then he came back and said, when I said blue, I actually meant red. So these are efforts to persuade and to tie together all the many things you've seen and heard, but that's not actually evidence. Witness testimony and the physical evidence that's been admitted. With that, Ms. Ocom, when you're ready.
Thank you. Good morning, ladies and gentlemen. Let's stand a little bit far, so I know I'm projecting. First of all, I want to thank you all. You've been great jurors. You took the time to copious notes and you asked lots of questions. And that's what I chose you. Chose you all because we were going to pay attention. We're going to take this seriously. You're going to do your jobs. Okay? This is State v. Dexter Beard. And why are you all here? Why are we all here? You're here because he killed Solomon Balan. That's why we're here. We're here because of him. What I did was wrong. That's what the defendant said. He knew it was wrong, right? He killed Solomon Balan over a dice game. Let me say that again so that it sinks. He killed a human being because of a dice game. Because he touched the bank. That's why he killed him. He killed, according to him, he'd known him for 10 years. He grew up in the same neighborhood. And he killed him because of a dice game. Mr. Balan is dead because of a dice game. Again, at 4 o'clock in the morning. That's why he's dead. I'm going to talk a little bit about the law and what the judge is going to give you. And then tell you how the facts fit into the law. And I'm going to have a seat. Ms. B, Ms. Feely, will talk to you. And then we're going to come back again and talk to you again. So let's talk a little bit about your duty. What is your duty? You're here because you're supposed to be a fair and impartial juror. You're not here seeking doubt. You're looking for the truth. You're here to seek the truth. Speak power to truth, as people like to say, right? You're here to find out what happened. What really happened in the early morning hours of June 3rd of 2014. That's your job. Now, what's the truth? The truth is, we know it happened in Fulton County, right? It happened on Auburn and Bell Streets. That's the truth. What is also the truth? We know it was the defendant that was there, right? That's also the truth. What is also the truth? We know that Mr. Balan is dead, Solo is dead because of a dice game, right? That's the truth. It is what it is. He killed him because of a dice game. What's also the truth? The defendant emptied his .357 Magnum revolver, right? The gun can only fit 6 bullets. When it was found that same day, that's when Mr. Rowland found the gun and called the police. All 6 casings were missing, right? All 6 bullets had been fired. And there were only 6 casings left in the revolver. So we know he fired on it, right? That's the truth. We also know that the gun was thrown over the fence. That's the truth. Right by where he was. So who threw it? He did. What a detective needs to tell you. Anybody could throw it. over the fence. It was low enough that anybody could throw it. We also know he wasn't shot anywhere in the upper extremities, so his hand was just fine. So he threw the weapon. That's also the truth. What else is the truth? He tried to run to his vehicle. How do we know that? He tried to get into the car. There's blood. He couldn't drive. Why? Because remember what Dr. Banner said? It hit his butt and he hit the artery. And he was bleeding and that leg was gone. And so he came out and got behind his car. So we know he's right to run. That's the truth. We also know he lied to Detective Meester. That's also the truth because you heard it yourself. That's the truth. What is your duty? Everybody, your duty as jurors is to deliberate. Now, I don't have any issue or problems with that because like I said, you all have been paying attention, you've taken notes, you've asked good questions, so I know you all know deliberate. However, if for some reason, which I highly doubt, a juror doesn't want to deliberate, you tell the judge, look, Bernie, hey, this juror is not participating in what's going on. But I'm confident, based on how you all have paid attention, that this is not going to happen in this juror. Let's talk about what your duties are, right? What you can consider and what you cannot consider. You cannot consider passion. You cannot consider public opinion. You cannot consider if you're unhappy with the police. If you don't like the fact that what Detective Dennis cuffed Kiki before he took him to talk to Detective Denise, if you don't like that, it's fine. You don't like it. You can't consider it in seeking the truth, right? If you're unhappy with the fact that Detective told Car Wash that there are surveillance cameras, and the surveillance cameras we found out later on, because at the time you didn't know the surveillance cameras weren't working or they weren't operational. That he told Car Wash that, look, there's a video, there's a camera. If you're unhappy with that, that's fine. We don't get to consider it in seeking the truth in this matter. Public feeling, sentiments about it's 4 o'clock in the morning. Why are they all out there gambling? Why is Solomon out there at 4 o'clock in the morning? Why did Solomon leave his girlfriend in the vehicle even though she wanted to leave and was gambling? You don't get to consider sympathy. You get to feel sorry because you're here to seek the truth, facts, the evidence of what happened. We talked about this in detail in more dialogue, right? You don't get to say just because you don't like the law should be something else. This is not what I personally believe. You don't get to consider that. You don't get to consider conjecture. You don't get to consider penalty and punishment. That is all judgment brings job. You don't get to consider what would happen once you come to a decision. That is the purview of the court. You also then get to consider prejudice, right? The fact that the witnesses, it was 4 o'clock in the morning and they're out there gambling and drinking. You get to consider what's inside the circle. Why not doesn't work? Inside the circle, right? The law. The testimony of experts, we had a couple of them, right? There were multiple experts that testified. There was Dr. Banner, there was Dr. Sullivan, there was Banner Kelly, there was Christine Steele. We had all of these experts come to educate you, to let you know what happened that day. You get to consider that. You get to consider the testimony of the witnesses, what they remembered, how they remembered it, how their testimony changed over time, how by the time you get to the 4th time they're talking, they're saying something else. You get to consider if a witness said the same thing, no matter how many times they asked her, they said she said the same thing, Bibi. Because you know why? You don't need to remember the truth, because the truth is what the truth is. It never changes. But then if you lie, you gotta keep up with it. What did I say the first time? What did I say the second time? What did I say the third time? By the time I get to court the 4th time, what did I say? But the truth never changes. It is what it is. No matter how many times you ask, it is the truth and it remains the same. And then you use your common sense. You're all smart. All had life experiences. Get into the sport. you're all, your common sense and your logical thinkers, you're smart. You need to park that at the door and believe anything that's ridiculous just because it's said. Your common sense and your logic also applies. And of course, the elements of the crime. So let's talk about the legal principles, right? The presumption of innocence, right? You've all heard that. Legal presumption, defendant is presumed innocent until the state proves him guilty beyond a reasonable doubt. You've all heard that. Everybody says that all the time. So the presumption of innocence is just what it is. It's the presumption of innocence. It doesn't mean he's actually innocent. It's just that you presume him innocent until the state proves he's guilty. Right? That's what that means. When I said the state rests, that presumption is gone. He's no longer presumed innocent because he's guilty. The evidence that the state provided from here, the witnesses, the exhibits, everything you saw, you heard, audio, all of that remove that presumption and the defendant is guilty. Reasonable doubt, right? We talk about it all the time. State has to prove that the defendant is guilty beyond a reasonable doubt. It's a legal term. But what does a reasonable doubt mean? Right? Just what it says. Reasonable. It has to be reasonable. It can't just be anything. You have to find a reason based upon common sense. Doesn't mean that it's vague or arbitrary or for which I'm kind of not sure. I don't know what's going on. That's not how reasonable doubt happens. Reasonable doubt is there has to be a reason, right? It's based upon your common sense. Beyond a reasonable doubt is not that the state answered all your questions, right? It has to be, because the only two people that were there, right, that will tell you everything that happened as it happened, we weren't there, right? We have to provide to you what we got from the evidence. From when crime scene technician Ma got on the scene, all the things he collected, when Detective Denise investigated, all the things he investigated, all the people he talked to, how he tried to talk to people. We give you all of that. But we can't answer all the questions. Like we can't tell you what is on Mr. Belai's phone, right? That was a question. But we can't tell you that. Why? Because the phone was locked. We couldn't get into it. And in 2014, there was no way to get into a locked phone. That's a question that a juror would have liked the answer to, but we couldn't answer that. Does that mean that that's a reasonable doubt? Absolutely not. Because the fact that Mrs. Belai had a phone that we couldn't get into has nothing to do with the fact that the defendant shot and killed him. Has nothing to do with it. But that's a question. That is why the reasonable doubt doesn't mean the state answered all my questions. It means a doubt by which a reason can be given. If you believe he did it, then he did it. It's not, I believe he did it, but because we couldn't get into Mr. Belai's phone, then I have a doubt. That's not how that works, right? He did it. He's guilty. I like to give an example, right? Because I said in the I'm from Nigeria. So I went to undergrad at The Ohio State University. So one guys, he wants to Georgia. So I let that go. And I went to law school in Wisconsin, right? So I'm from an African continent, so it's always in the community, so it doesn't matter what year, the time, it's always in fantastic, sunset, beautiful. Went to law school, Wisconsin. And I don't know if anybody has been to Madison, it's beautiful in the spring, but then come winter. Yeah. And then the interesting thing about Madison is that it never closes. Doesn't matter if it's blizzard, it's snowing, you still get to go to class. You still get to go to listen to the professor talk about contracts. This is the thing. Like school children go to school, everybody goes to school. So then you're talking about this going to be particularly bad for, you know, how the weatherman says for the week. This is going to be the worst winter storm. I think we're going to probably close things down. because this is bad. The first day is just freezing cold. It doesn't really happen, right? So we also have a class with classroom. Second day, doesn't really happen either, but he's saying that it's gonna happen. So then I go to bed, and then I wake up when everything is covered in snow. Everything's like you can't see. The car is covered, sidewalks, everything is covered in snow. And then they say they're canceling school because we really at this point can't get into class. Now, I didn't see it snow, right? Because I was sleeping. I was sleeping. Let me see it happen. Now, is it possible the movie crew came by and poured fake snow all over the front of my apartment? Is it possible? It's possible, because now the movies can do pretty much anything. They can simulate rain, they can do snow. Is that reasonable? If I tell you that even though I was sleeping and my front of my apartment in Madison, Wisconsin was covered with snow, that some crew came and did that, is that a reason? Absolutely not. Because what is reasonable is that it snowed. Even though I didn't see it snow, I live in Madison, Wisconsin. I'm going to school there. It snows. It's cold. It's terrible. So therefore, even though I didn't see it, I know I can rely on the fact that it was snow and it came from the sky and not from some magical spaceship or a movie station that came and poured out white things in front of my apartment. That's how reasonable that works. People can't just throw out things and say, it's possible that this happened. Yes, anything's possible. People say that all the time. But is it reasonable? It's not. What's reasonable is that I went to bed, it snowed while I was sleeping, I woke up and I didn't have to go to my contract's house. That's really what happened. As in the law for you, the judge will give you the law. The testimony of a single witness is sufficient to establish a fact. If you believe a single witness and you believe what they said, then that fact has been proven. You don't have to have somebody else tell you that. You don't have to have corroboration of that. If you believe them, then that's what it is. That's a fact. That's what happened. Intent, right? You have to prove the states that you intended to do what you did. So what's intent? Intent is not the intent to violate the law, but the intent to do the thing that is illegal, right? If one commits an unlawful act and another victim is harmed, you don't get to say, well, I wasn't trying to harm person A, B, I was just trying to harm person A, so I didn't do it. It's logical, right? Everybody understands that, right? It makes sense. Mr. Belai was killed by the defendant. So the defendant was trying to kill Mr. Belai. In the process of trying to kill Mr. Belai, he shot Mr. Bailey and Mr. Martin. He doesn't get to say, well, I was just shooting at Mr. Belai. And the fact that Lil B and Lee Bailey got shot when they were crossing the street, I shouldn't be held responsible for that. That's ridiculous. That's what we call transparent intent. Just because he wasn't trying to kill, I mean, we all agree that it was Belai he was trying to kill, right? He was trying to kill him because he shot him 5 times. He was trying to kill him. But because it was a through and through, and he got to Lil B and Lee Bailey, he doesn't get to say, well, they just happened to be crossing the street, so I'm not guilty of that. That's not how that works. You shoot somebody, and while you're shooting the person, somebody else gets hurt, ding, 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 you're just as guilty for the other people that got shot. And it makes sense. It's common sense and logic. It makes sense. You don't get to say, because I was trying to kill Mr. Belai, and unfortunately, Lil B and Lee Bailey got hurt. I get to get away with that because that was not where I was trying to go. You don't get to do that. So he's just as guilty for that. Let's talk about what evidence means. What is evidence? Evidence is the means by which any fact supporting issue is established or disproved, right? There's direct evidence, and then there's circumstantial evidence. Let's talk about that, right? So direct evidence. Direct evidence would be Bibi, these were in Casa. She sat here and she told you what happened. When she came out and she demonstrated what happened, what she saw, right? She was in the car. She heard the commotion, she didn't know what was being said, and so she looked into her mirror. And then she turned and saw the defendant with his arms stretched. And she demonstrated it to the world. She came down and she bent. And she saw Mr. lie on the ground. So looking at him, speaking of something, money and the dice was on the ground. And she saw the defendant with his arms outstretched and boom. And then she jumped, right? That's direct evidence. Bibi saw the defendant shoot. So, right? She saw that. That's eyewitnesses. Now, circumstantial evidence has the same weight as direct evidence. Same weight. But circumstantial evidence is proof of one or more facts that tends to prove or disprove some other fact by inference. So that's why I keep saying common sense, right? So use your reason and inference and your common sense to make deductions, right? So let's think common sense and reasoning, right? Everybody agrees that Mr. Bly was on the left, right? Solo was on the left. Deck was on the left. Also maybe was on the right because he ran towards his car to be behind him on the right. So Solo was closer to Auburn. And the defendant was on the other side, right? It's also common sense and reason and logic that the defendant shot while Solo was on the ground. Because how else did he get that injury to his back? How else does he get the gunshot into his back? How else? Because if he's up front and he's facing him and he's shooting, remember, Solo has the high-powered weapon. He has the 40 semi. Right? And he's 5'11" and 200-something pounds. So he's tall and he's big. How does the defendant get shot in the butt and the upward trajectory? How does that happen? How does that shot happen? How? What magic? How does Solo do it? He's 5'11". He's a tall guy. He's big too. How does he shoot the defendant in the butt? And what did Dr. Banner tell you? It's an upward trajectory. So he went from his butt and went up and came out of the groin area and hit the vessels that caused the injury to go in, that caused him to go through surgery. How does that happen? Common sense, deduction, and logic tells you that Solo was on the ground when that shot happened. And the only reason Solo was on the ground when that shot happened was because the defendant had already shot him. Because why else would a 5'11", 200-pound guy be on the floor shooting? And they're that close? Because according to everybody, they were feet, because they're playing dice, right? So he's right here. And I'm shooting first, and I don't hit any of your front extremities? How? With a semi that had at least, we know he had at least 12, and he used all 12. Because we found 12 shell cases, right? That's what Officer Pengman said. 12 shell cases were found. And what did Lana Kelly tell you? All of them came back to the gun. How is that possible? How? What magic is that possible? And how does he do that if he's not on the ground? Let's talk about evidence. So evidence, all of it, we keep talking about it, comes from here. The pictures came from here. Audio came from here. Everybody, the pictures, everything you hear that's evidence is from here. That's all that's evidence. Questions are not evidence, right? what the witnesses say, the pictures you see, the photos, the audio you hear, that's what evidence is. What Bibi told you, what the expert witnesses told you, what Dr. Banner told you. He was shot multiple times, he was shot twice, but they called it 4 holes. Why? Because there's an entrance and an exit. And both of them to the back, both of them upward. How does that happen if Solo is not on the ground? How? What did Dr. Karen Solomon tell you? All 5 shots, downward, to the back, downward, to the left, to the arm, downward, to the side, downward, on the butt, downward. How did all 5 shots happen in a downward direction? Directly to a 5'11". I keep saying he's 5'11" because I'm 5'10". I'm tall. How does that happen? How? What did Roland tell you? It was the same morning you found the gun. Your .357 Magnum, you don't remember what you did with it? The gun you've had for months, and you really supposed to. What is this? We're really supposed to believe that. And I didn't throw the gun, but the gun just happened to be on the other side of where you were, where the ambulance picked you up. So we did the magical Ferris came, took the gun from you, tossed it over the fence, and you just laid there. Who did that? Magical people. Your fairies just scurried, oh, he has a gun, get him to it, just threw it over the fence. You don't know anything about it, and just gonna go to the hospital. How does that happen? What about Detective Lisa? He did everything, right? He recorded everyone. He kept going back to the scene, trying to see if anybody would talk to him. He kept giving out his cards. He went to the vigil. Officer Pegman, what did he tell you? I was there for hours. You saw all the, they took cigarette butts. They took every single item on that ice. What does that tell you? All of it says he's guilty. Example exists. Okay, Bibi picked him out of a lineup. That's where the gun was. So there were multiple people out there, right? Multiple people got shot. Why would she pick him? Why would Bibi pick him? What is the reason for Bibi picking him? Right? Why is it him that she picked, right? Because there were other people out there gambling. Other people got shot. Why does she pick Deck? What is the reason for her picking Deck? Why would you say Deck did it? Why? What's the beef? What's the drama? What did she have? What is it? That of all of the individuals that were there, some she knew, some she didn't know that she picked him as a shooter. Why would she do that? If he didn't do it. You get to decide the credibility of witnesses, right? You get to decide who's telling the truth. You get to decide what you want to believe and what you don't want to believe. I told you about that in the opening. Take notes, but pay attention to witnesses when they talk. Their demeanor, what they sound, what they suddenly forget, what they suddenly remember. All of that is important. How each time they testify or they talk to somebody on the oath, I promise. Truth, nothing but so help me God. Right hand up. And every time something new comes up.
That was a pretty good sound effect. Someone has logged in. Are we better?
I'll just keep going. Something new pops up, right? It's always something new. After raising your hands and telling the truth. So every time you forget that you're telling the truth, and something, you just add new information, or you just suddenly forget everything that happened. That is important. You take note of all of that. Now let's talk about self-defense, right? I shot him 5 times because he allegedly shot at me, right? A defendant, this is the law, a defendant is justified in using force that is intended or likely to cause death or serious bodily injury when he believes the force is necessary to prevent death or serious bodily injury. Solo, in all agreements except his speech, right? The defendant was playing the dice game and he was putting 5s on top of hundreds, and so Solo couldn't see how much he was going to pay out or not pay out, however he was using them, right? So Solo is on the ground, and according to the defendant, he was trying to get dice, trying to get whatever it is he claims that he was trying to do. But what does BB tell you? He was on the ground. He looked like he was getting something on the ground. Where is the threat? You know how we also know his back is to him? Because he got the perfect shot when he shot him in the back. Right? Where is the threat? He supposedly had a 40. You all have, most of you have fired guns. Some of you have been in the army, fired everything, right? We all know semi beats a revolver, especially a loaded semi with 12 rounds in it, right? And he's on the ground, or he's allegedly trying to shoot you, and you're facing him and you're feet away from him, and he gets not a single of all of the shots he fired, 12 of them, not a single one hits you in the front. Not any. And you're right in front of him. How does that happen? What magic is this? That he shoots 12 times, not a single shot gets you on the hip. And then the only 2 shots that get you are on the behind going upward. How? And you get to your car, and Solo doesn't because he dies a few feet from where he is, right? He slumps right there. He doesn't get to run. So that means he was standing right there. And we also know he shot with his right, right? So if he's shooting with his right, right here, and you're right there, and he gets to jump on you because he's shooting with his right, how does he get all the gunshot wounds to his left side? And how does he get shot in the back? And how are all of the shots downward? How? How does that happen? It's not, doesn't make any sense. You know why? Because it didn't happen that way. So he had to jump. Because if Solo had to jump, he might have many more shots. Because what is he? The perfect shooter. You get perfect shots to the side, 3 of them, 1 in the back, 1 in the behind. And somehow the guy with the 7 doesn't get a single shot to your front. Because that's not how it happened. He had his back to him. Like BB told you, he was on the ground. Like Benny said, Lil B, until he conveniently forgot everything. Like when he told Detective Demista. Everybody knows that Solo was on the ground and then the defendant shot him. Now the state has the burden, right? You have burden beyond a reasonable doubt that it's not self-defense. It's our burden to prove beyond a reasonable doubt that he did it. And we carry that burden. And we're happy to carry that burden because the defendant did it. And all of the facts, the physical evidence tell you what happened. Right? You don't even only have to rely on witness testimony, you can also rely on the facts and the evidence. The scene tells you what happened. The defendant is not justified in using force to reports the threat. And he did. He's the one that pulled out his .357, his Magnum revolver from his hip. He doesn't get to pull out his gun and say, well, Solo fired back, so it's self-defense. That's not how that works. You shoot, you don't get to say, well, oh, he shot me back. You started it. You don't get to claim self-defense after that. That's not how the law works. You're committing a felony, you're brandishing a weapon, you're pointing a weapon, You don't get to claim self-defense. You don't get to say, I was defending myself when you started it. You don't get to be the one that brings a weapon into an argument and then claim self-defense. You don't get to do that. The law is clear on that. You don't get to be the initial aggressor. You don't get to be the one that commits a felony and then claim self-defense. You don't get to do that. You started it. And this idea that his friends had weapons, that's even more ridiculous than the other ones, right? His friends, his boys had weapons and were beside him, semi-automatic, and they didn't shoot. Really? They just sat there with all, because they're on the side of Solo, right? So they're being shot at, and they all have weapons, and they just what? Just hold on to the weapon and just stand by and get shot at. Really? Their weapons are out? Really? And they just watch. And the defendant is not shot up completely? How? That's so, like, really? You don't get to say that, well, he was upset, he was talking, he said I was cheating, I get to shoot him. Words are not enough. There has to be some sign that deadly force is needed, right? The belief must be reasonable. You can't say because he's upset at you that you're cheating him. Your boy that you've known, allegedly, according to him, for 10 years, we have no problem, we have no beef, and because he's upset that you're cheating him, and you know you're cheating him because you said you were cheating him, then you get to shoot him and then claim self-defense. In what world is that okay? It is not okay. And you know what else everybody agrees on? You don't touch the bag. I've never been school you know anything about it. And so not even can do sure I understand how you perceive it. But what I did get was you don't touch the bank, right? Because I was like, why can't I touch the money? And then the attitude, the demeanor, everything just changed. So I was clear. You don't touch the bank, you don't touch the dice, unless you're about to shoot the dice. And you never touch the money. And that's what Solo did. And Solo had already lost. We know that because he said he was cheating. So you can't take money when it's not your money anymore, right? So I apparently understood the rule. Everybody knows this. You don't touch the bank, you don't touch the money, especially if you're losing. And that's what he did. He went to get his money because he was upset that the defendant was cheating and the defendant shot him. Was it ego? Who knows? Was it because it's an unwritten rule in the streets that you don't touch the money? Gotta protect my credit, my standing, whatever it was. The fact is that he went for the money and he shot him. The defendant doesn't get to claim self-defense. Mere words are not enough. Just because he's angry and mouthing off and saying, you're cheating me, even if he said, fuck you, maybe 100 times. Even if he said that, it's not enough for you to shoot him 5 times. You're ready to kill somebody because of what they said. You're ready to do that. Remember what he called him, how offensive it was. You're ready to shoot him because of that. What if he's making you look bad in front of your boys? What if he's questioning your manhood? You get to kill him because of that. You don't. The law doesn't let you kill somebody because of what they said, because you said fuck you, okay? You get to kill him. And shoot him 5 times while he's on the ground because he's picking up money and he's mouthing off. You get to do that. Not in the state of Georgia, not in Fulton County. You get to do that. So this is a 6-count indictment, right? It's murder, felony murder, aggravated assault, 3 counts. 1 against Solomon Bly, 1 for Lee Bailey, 1 for Benny Martin, and 1 for possession. 6 counts is possession of a firearm during the commission of a felony. I'm gonna go through that, right? It's the elements of a crime. start with the most serious one, murder. What is murder, right? Murder, you're guilty of murder when the person unlawfully, with malice aforethought, causes the death of another human being. Now that's just legalese, right? Malice aforethought, right? What is malice? I mean, when most people hear malice, they think it's, I'm thinking about this guy, I'm hating him, and I have malice for it. But that's not what legal malice is. Legal malice, there are two types. There's express and there's implied. Express malice is the deliberate intent to kill someone. I intended to kill somebody. So remember what I talked about intent? It's what you intend, when you intend to commit the act, that's intent. I intended to kill Solomon Bilal. The defendant intended to kill Solomon Bilal. Do we know that? Because he shot him 5 times, or 6, he just missed the 6th one. He intended to kill him. You put a deadly weapon, you shoot somebody, you intend to kill. This is implied malice mean. There's no provocation, an abandoned and malignant heart. That's just legalese, right? Does it mean that your heart is somehow rotten or dead? It just means you did what you intended to do, right? So murder is without justification or excuse. You try to kill somebody without justification or excuse. So this was not self-defense. He was not justified in killing Solomon Bilal. He had no excuse for killing Solomon Bilal because all Solomon Bilal was trying to do was get his money, even though he lost his money. That's the truth. He lost his money. He was trying to get it, and the defendant killed him. You don't get to kill somebody because of that. You don't do that. And everybody hears about premeditation, right? I planned it before I did it. That's the first degree murder, second degree murder. That is not in the state of Georgia. In the state of Georgia, it's just murder. You don't have to plan it. Intent can be formed in an instant. I intend to do it, I do it, that's intent. You don't have to plan it. You have to think about it before you kill him. To the defendant, that's exactly what the defendant intend to kill Solomon Bilal, absolutely, right? Solo touched the bank. He was on the ground. He shot him. All the shots were downward trajectory. Every single shot. Shot number 1. Dr. Sullivan told me, gunshot number 1 to the back, downward. Gunshot wound to the arm, downward. Gunshot wound to the torso, downward. Gunshot wound to the leg, downward. The one at the back, downward. Every single gunshot wound, all 5 that he got, were all downward. So you have to be on top of him because again, Mr. Bilal is 5'11". He's a big guy. You don't get to, so how did he shoot him? How did this shot happen? Who was with his hands up here? How did that happen? And he's shooting him, as he claims, and he's running away. So his right side is to him because he has the gun. So what does his bullets curve? Do they like go up in the air, so do, and then come down? So he has magic bullets that nobody else has heard of because we all know that bullets go in a straight line until they hit something. Everybody knows that. You shot a gun, it goes straight until it hits something. And if you were that close to him and it's through and through, it didn't hit anything. But his bullets are magical. They just carve up in the air and come down. He shot him in the back. He emptied his revolver, he tried to get rid of his murder weapon, and then he lied. I was coming, he has all these details and he suddenly remembers, but he forgets the entire parts. I remember I was coming from the Clone of Abrahams. I remember that. I remember it was on Auburn, I was going to my car, I was like, oh yeah, remember that also. I remember I left Dre, my brother, he was with me when the club, and then he left. I remember that as well. I remember I was walking to my car and all of a sudden shots just magically appeared. Remember that? I remember I shot just one time with a 38 semi-automatic. Remember that? Okay, so where's the gun? Don't remember. Was Solo there? Don't remember that either. Don't remember. Who else was out there? Don't remember that as well. Don't remember that. Don't remember. Detective Denise even tried to help him. Look, if he was trying to shoot you or something happened, just tell me now. Yeah, don't remember that as well. Look, we found 2 guns. We found a 40, a 38, 357 Magnum Local, which is his weapon, right? Because he's had it for a couple of months. Any of that? Still don't remember. Really? Felony murder. A person is guilty of felony murder when a homicide is committed during the commission of a felony. There must be a connection between the felony and the homicide, right? Malice is not required for felony murder. So what does felony murder mean? The defendant was involved in a felony. Yes, he was. Aggravated assaults. He had a weapon. I'll come to that. Someone other than the defendant dies. Somebody did. So on the line, he's dead. What does that give you? Felony murder. So while he was committing aggravated assault, someone on the line died, felony murder. During the commission of the aggravated assault, he caused the death of Sullivan Blight. So let's talk about aggravated assault. What is aggravated assault? A person is guilty of aggravated assault when he assaults another person by shooting, right? The truth is, we all admitted he shot Sullivan Blight with an offensive weapon, a firearm. Everybody knows a 357 Magnum revolver is a deadly weapon. In fact, he knows it's a deadly weapon because Sullivan Blight is in fact dead. Did he cause the death of Sullivan Blight? We also know that is true because what did Dr. Sullivan tell you? The kill shot, the one that killed him was the one from the back where they found the 38 bullet fragments in his abdomen in there. And what did Van Kelly tell you? That came from the 7 Magnum revolver. It was a match. It matched all the shell casings and the projectiles on the scene. So they went to the 40 or they went to the 357 Magnum, right? Aggravated assaults. The aggravated assault of, so he's guilty of that. So aggravated assault of Mr. Bailey and Lil B, right? Those who were shot in the arm and the shoulder. He wasn't trying to shoot or kill Lee Bailey or Benny Marks. He wasn't. However, when he was trying to kill Sullivan Blight, he shot. His bullets, they were through and throughs, right? They were all through and throughs. Ended up through Mr. Bailey and through Mr. Martin. So you know what? You're guilty of it as well. And we know it was his weapon, because remember, Mr. Bailey and Mr. Martin were on Arbor. So they were on the opposite side of him. And Solo could not have been shooting back at his back, right? Because he was here. That's Auburn. This is Bell. Solo wasn't shooting that way, right? He was shooting at the person that's in front of him that tried to kill him. The only other person that was shooting, because there were only 2 people shooting, the defendant admitted there were only 2 people shooting. Defendant and Solo. So the Solo is shooting that way. And Mr. Martin and Mr. Bailey are behind him. It is impossible. Impossible that it was Solo. Impossible. If he wants to argue that it was Solo's friends, impossible. Because they'd all be shooting in that direction, which nobody else was shooting because there are no cases, there's nothing else on scene. No other fragments, nothing. Except the 357, the 38 bullets that came from the 357 and the cases that came from the 40. So we know only 2 guns. 2 guns. The one gun is shooting that way, the other gun is shooting the other way. So the only gun that could have shot Mr. Martin and Mr. Bailey, the defendants. Again, we all We agreed that 357 Magnum revolver is an offensive weapon. Is he likely to cause death? Yes. A lot is in fact. Possession of a firearm due to commission of a felony. This is what it says. The charge itself is what it says. You're guilty when you have on you or within arm's reach a weapon which you did during the commission of any of them. So during the commission of the murder, during the commission of the felony murder, during the commission of the aggravated assault, he had his weapon because he used them. He used his weapon. So he's guilty for count 6. Now motive. No proof of motive is required to prove murder. Evidence of motive, if any, is admitted to show the state of feeling between the victim and the defendant, if any. So the state doesn't have to tell you why, right? We have to tell you why he did it. We have to show you that he did it. We just don't have to tell you why he did it. And that makes sense, right? Because the only person that knows why he did it is the defendant. He's the only one that knows why he would kill Silman Belay over a dice game at 4 o'clock in the morning in front of people. Only him knows that. Only that superior knows why he killed him. That's why we're not required to tell you why. We're required to show you that he did it. If there's evidence of motive, it's helpful, right? And we know what the motive is, right? Money, greed. But he says it all the time. Money is the root of all evil. Causes all sorts of problems. Money. And we know there was a lot there, right? They've been involved in gambling for hours. So there was a good stack of money on the ground. So that's why he did it. We don't have to tell you why, but we know why he did it. He did it because of So ladies and gentlemen, defendant is guilty. He knows he's guilty, right? This is over money. A good amount of money on the ground. So money involved. He empties his revolver. He tried to get away. He didn't get far because unfortunately the gun hit, or fortunately, depending on how you look at it, hit the vein that caused that leg. That was it. And he slumped in the driveway because he got in the car to drive, but he couldn't because that right leg wasn't working. And so he got out. He tossed his weapon, but for him, Silman Belay is not dead. Ben Martin is not shot. Lee Bailey is not shot. Even Sergeant Jeffries is not shot, but for the defendant. Nobody is shot. We're not here. We're not doing this, but for him. But for his decision to shoot somebody over a dice game, nobody's here. Nobody ends up at Grady. All 5 of them don't end up at Grady. He doesn't end up in the hospital for months. But for him. Cassidy find him guilty on all of it. Count 1 murder, count 2 felony murder, count 3 aggravated assault, 4 and 5 aggravated assault, and count 6 possession of a firearm due to commission of a felony.
All right, thank you, Ms. Okram. I have you using about an hour of your time there. Ms. Feely, if you're ready.
Solomon was mad. Solomon felt she did. And Solomon opened fire on that guy's game. Before you know that, what this boils down to is what happened on Bell Street and Auburn Avenue at 4 in the morning in a very short split-second period of time. The state's whole theory is just the reverse of what actually happened and what makes sense that happened. Solo, this is my money, put it down. Don't move, nobody move with me. All these broke ass people around here, ain't nobody got no money, they're all broke, put the money on the ground. How are y'all gonna take my money? Y'all killed my brother Bijou. Man, it ain't that serious. Those are not the words of somebody who's about to open fire. Solos are. We continue without the technology. I'm just gonna talk to you.
Okay.
Solo lost the rent money. You heard Ms. Costa talk about how they had been living in a hotel to hotel, but they had found an Ethiopian family who was gonna rent to them even though they didn't have jobs. Wonderful. It's great to have community. Solo had the money for the rental house. And then they went out, had a great night. We don't know what was in Ms. Costa's system, but she did admit to drink, said she was drinking, but she also told you about what Solo was drinking, and we know that's not true because we do know his blood alcohol level, what it was afterwards. So we know she was either mistaken or not being truthful about how much he had had to drink. It won't do this massage. So the very next day, she testified they were going to go and get this hotel. So on the way home, very late, early in the morning, they stop, they're on their way home and Solo's driving and he says, and let me just stop and see what's going on over here that I see. Mr. Jeffries told you, and some of you may have already known this type of quick gameplay is a very quick way to win a lot of money, very quickly. Also a way to lose a lot of money quickly. So what happened was he went and started playing and was losing. He started losing. And then you heard from Kiki, he took over the bank. So he's taken over the bank. He's now having to pay out, as we kind of all understand now how it works, is he's got the bank, he loses the round, he pays out the people however much they put into that particular round. So he's losing a lot of money really quickly. Ms. Casa is waiting in the car for him. Is he really gonna go back to that car empty-handed or with much less money than he went with? Ms. Casa told you she sent Awet to get him, another person that is in his inner circle. He still won't come. She says she called him, texted him, he's still playing. Pretty early on, it becomes, now it's Solo's backstage. This is frustrating for him. This is upsetting for him, just this part. That he's losing, he's lost money that he intended to use instead of coming away with a little more cash in his pocket. Now he's in trouble. This is a problem for him. This is my only opportunity to talk with you, so I am going to talk with you about the law as well. So you're going to have the indictment back there with you. Count one, malice murder. The state is alleging that Mr. Beard intentionally, maliciously killed Solo. That is not what the evidence shows. Count two, felony murder is murder. When you're back there, don't get it twisted. Felony murder is murder. The elements are slightly different, but it's murder. If you're convicted of felony murder, you're a convicted murderer. Count three, aggravated assault against Solo. All of these first 3 cameras, we have raised the defense of self-defense, saying, even if we shot, we were under fire. We shot in self-defense. When the defense raises, and I'm going to get into a little bit more of the law on that, the state has to not only prove the elements in the indictment, they have to disprove that Mr. Beard was acting in self-defense. Disprove, and the burden is the same. They have to disprove beyond a reasonable doubt that Mr. Beard was justified when he was under fire and returned fire, if that's what you find the evidence shows. Count 4 is aggravated assault against Lee Bailey. Lee Bailey has said repeatedly he doesn't know who shot him, he didn't see. What we do know is that Solo unloaded his clip on the dice game. We do know that because there are 12 shell casings there at the scene. We know that both Lee Bailey and Benny Martin had 3 injuries. We don't know exactly what bullet shot them, but we do know it could have been one of those 12 rounds, at least 12 shell casings, could have been 14, that Solo fired in that very close proximity. These are people who are very close together playing the game, lots of movement. Mr. Jeffries told you there's not assigned seats, and so people are moving around. He couldn't tell you exactly where every single person was when Solo opened fire, but it's clear from the physical evidence that the state presented you that Solo opened fire on that dice game when people were in close proximity. So both the aggravated assault of Lee Bailey and Benny Martin, there is simply not evidence, much less evidence beyond a reasonable doubt that those bullets came from Mr. Beard. Count 6 is possession of a firearm during the commission of a felony. You cannot convict him of count 6 unless you find him guilty in counts 1 through 5, because what he was doing was not a felony. What he was doing was defending himself. So there's no other reason he couldn't have a firearm legally. There's no reason that what he did in that moment was not justified behavior. Therefore, count 6, possession of a firearm during commission of a felony, he is not guilty of either. So let's talk more about the state's evidence there on the scene. Now, I'm not a mathematician. I know some of you have math in your background or math adjacent degrees, but it doesn't take that to see the problem here. We know that at most there were 6 bullets in Dexter's in the revolver that Mr. Beard's. There were 5 bullet wounds for Solo. There was 1 bullet that hit Benny Martin. Again, we don't know what type of bullets. 1 hit Lee Bailey and 1 you heard hit Mr. Jeffries. So what we're seeing here with the number 5 next to it is a bullet. Could have been a through and through of somebody. Maybe Benny Martin, maybe Lee Bailey, maybe Senator Jeffries, maybe another person, because what we know from Solo is that you can have gunshot wounds and just keep it moving. That bullet right there was never tested for DNA to see where it came from, whose body it went in and out of. It's marked, it's there, it's in evidence. It was never tested for DNA. And the state argued to you very vehemently that it is ridiculous to think that more than these 2 people had guns at 4 in the morning on Auburn Avenue. Of all those people that you heard about, people that you didn't come in to testify, but that you heard were there, you heard different, 10 to 12, 10 to 15 people were there. It is not ridiculous to think that there were more people with guns than the people that you heard from and heard about. This may not be your lifestyle, this may not be your part of town, but at 4 in the morning on Auburn Avenue, to claim that it is ridiculous that only Mr. Beard and Mr. Belay had guns is just, doesn't make sense with what we have seen from the witness stand and heard. All those people and only 2 guns, I think that sounds more ridiculous. Now, the state has
not only this math problem, they also have a geometry problem. The state has been arguing to you that how important it is that the trajectory is down. And that the only explanation for that is that Solo was way down here on the ground and somebody was shooting over him. But that's not how geometry and trajectories work. It just has to be slightly up, because you'll see the medical examiner's report before. You have, if somebody is pointing like that would cause a downward trajectory. If somebody is holding the gun and it's just slightly pointed down, we're not talking about it has to be like this. And that's not what the medical examiner's report shows anyway. It shows a gradual downward trajectory, meaning he could have been standing up. And the state is relying very heavily on you believing that that shot in the back was the first shot. And there is not any evidence of that. Dr. Sullivan told you she could not tell from her expertise, which is vast, which bullet came first and which wound came first. And it is a wild jump of speculation for you to go to the back shot was first. He was shot 3 times in the front. So if you get shot in the back and then you turn around and then and again, we're talking about Mr. Beard only has 6 bullets at most. What makes more sense is that he opens fire, Mr. Beard, somebody else perhaps returns fire, and then he takes cover. At that point, maybe he was on the ground, but that's not how it started. And there's no evidence that it did. So when you're talking back there about trajectory, it's not this, it's more like this is what the trajectories show in the autopsy report. Because we're not talking about like here to here, we're talking, and again, you will see, and you'll have all of that information back there, but the state is making it sound like it has to be this to be a downward, and it's not. Mr. Beard was only shot in the back, if we want to go there. He wasn't shot in the front at all. He was only shot in the back. And when you heard Detective Demeester read his statement from the prior hearing, he says, he's winning. I think by all accounts, he's winning the dice game. Solo's game, Solo's got the bank. Mr. Beard is winning. Mr. Beard, through Detective Demeester, says he gets his winnings and he turns around to count them. Shot in the back sometimes. This is a state star witness. She's the only one who came in here and told you that Mr. Beard shot first. And I told you at the beginning, she is sympathetic, but she is problematic. Again, we don't know what her blood alcohol level was or what else was in her system, but we know she wasn't truthful about what Solo had to drink. Or was mistaken. We know that she was looking through the rearview mirror and then turned around. She told you she was on her phone, Instagram. Maybe she zoned out, maybe she fell asleep a little bit, but it was dark. And her testimony was that she turned around at the right second. She had heard a 2-minute commotion going on, and then she, through the rear mirror, she saw and heard this commotion going on. Couldn't hear what the exact words were. And then she just happened to turn all the way around at the exact moment where she saw Mr. Beard shoot first. She's the only one that says that, but that's what she says. I think it's very, very possible that what happened here was a classic example of a referee missing the first. I have two sons. And I think this is probably a universal thing where I hear a commotion, I go in there and I see the second action, right? I don't see the first kid do the push I come in just in time to see the second kid and get that second kid in trouble, because that's what I saw. I didn't see the first one. That doesn't mean it didn't happen. It just means that's what she saw. She saw the retaliation after the first shots were fired. The first shots being fired is what made her turn around. She would never say that, but that's what makes the most sense. She says the commotion was going on for 2 minutes. 2 minutes is a long time. What made her turn around was the 10 shots. And so then she very well may have seen retaliation. But that's what it was retaliation or return fire, but he was already under fire. He wasn't thinking he might be under fire, he was being shot at. So if she saw what she saw, that's the most reasonable explanation, because otherwise it doesn't make sense that she timed it perfectly to turn around to see the first shots after hearing 2 minutes of commotion. We've already talked about how dark it was out there, for her to see anything, and it took her a minute to remember, but she did finally remember that in preparation for another hearing, in this case, she testified that she was 28 feet by measurement from where this was going on. It's been a long time. A couple days ago when she testified, she said 5 or 10 feet. This is just how memory kind of changes as the story gets retold. One of you guys asked Detective DeMeester why it took 15 days to get a statement from her. And he was able to offer that she was afraid or fearful. I don't remember his exact terminology. She didn't tell you that. She didn't say that was why. She never told anybody that, and she certainly didn't tell you that. Detective DeMeester took statements from everyone else within a couple of days, few days after this happened. Miss Casa, she had 15 days. And what was happening during those 15 days? She was hearing things is what was happening. She was hearing the streets talking about what happened, and you heard her say she's from Stone Mountain. She doesn't have ties to Auburn Avenue. So who's she hearing it from? Solo's friends. She's not hearing it from any of Mr. Beard's friends or associates on Auburn Avenue. She's hearing the spin put on it by Solo's friends, because those are the only people she knows. Howard, Manny, that's who's telling her, feeding her information that could affect how she's getting her story together those 15 days later. He was her boyfriend. This was a traumatic event. Again, I'm not at any point saying she's not sympathetic and she did not experience trauma. But it just makes all the more sense why she would latch on to the story that's being, that the community that Solo is a part of is amplifying. They weren't there. We know that there were very few, 10, 12, 15 people there. But the streets are talking about what happened, and she's only hearing from Solo's friends and family. So of course, the version that paints him as in the best light is that he was shot at first, but that doesn't make it true. And certainly 15 days later, after she's been hearing all that, doesn't make it true. Let's talk about some other of the state's witnesses. I don't know that we heard why Phil got out of prison, but we do know that he had just gotten out of prison. We also know from Dr. Sullivan that he has been shot before. No one is gonna outshoot somebody who's been shot before. No one is shooting you first. Not with those evidence of 4 prior gunshot wounds. We know he was drunk. We know he lost money. Ms. Casa told you what that money had been earmarked for. The state brought you Mr. Huggins, I guess for the purposes of talking about the gunfire cadence that there's no notes of, but he somehow remembers the cadence of that gunfire. We know he's got his own problems. and was called as a state's witness and said what he said about the gunfire cadence, take it for what he will, from 7.5 years ago. Nothing happened to Ms. Cossett for talking. She never told you she was fearful. One of the state's last witnesses was Mr. Imam. And he gave one more motive, if you want to talk about motive, for Solo to open fire on this dice game. We don't know any more about it than what he said, but that sounds like a motive to open fire on a dice game as much as anything else. I don't know if the state's gonna say this, but they may, that they don't get to pick the witnesses that they call, because obviously, maybe these weren't witnesses that they would have chosen had they gotten to like have a casting call of people to call for witnesses. But this is the environment in which this took place. And the state doesn't get to pick their burden of proof either, based on their witnesses. The state still has to prove beyond a reasonable doubt every element of this indictment, of each count. And it's your job to hold them to that burden. And you took an oath to do it. And I trust that you will. So let's talk about Mr. Beard. You heard about his testimony at a prior hearing. This matches up more with what his physician said, came in here and told you about where his shots were. He turned his back to angry, yelling Solo, who's yelling, one of the witnesses said into the air, but what he meant was into pretty much to everybody playing. And he hears shots and feels it. He turns where the shots were coming from and Solo's shooting him. He was asked, did you fire your pistol before you got shot? No. The thing that the state will continue to harp on and has already harped on is the statement that in this same prior hearing, Mr. Beard was asked a series of questions, and at the end, he says, because I knew it was wrong. The state is going to try to convince you that that is a confession to murder. Because I knew it was wrong. A confession, full confession to murder, state's theory. But let's unpack that a little bit. It's a hearing in a courtroom like this. People in the gallery, court reporter. He's being questioned. What I did was wrong. No one in this case is at all happy that Solo didn't survive. No one. And all the decisions that Mr. Beard made that night leading up to what ultimately culminated in the shootout, he could have regrets about. Because all of the decisions, all of the small decisions that led him to be on that corner at 4 a.m. playing dice is what ultimately led to people being hurt and people being killed. But all the decisions Solo made did too. Solo, who just got out of prison, couldn't possess a firearm. It is one thing to feel remorse that things ended the way they did and you survived and he didn't. He did make a lot of choices that night, and Solo made a lot of choices that night. That if they had done something different, if Solo had gone on home, if Solo had not gotten upset, if Mr. Beard hadn't done whatever he did, if it was him that provoked Solo, made him so mad about the dice game, any of those things could be what Mr. Beard meant when he was questioned under oath and he said, what I did was wrong. that doesn't mean that he wasn't justified in what he did in that very short period of time, those moments. And your life may be very different from Mr. Beard. You may never find yourself at 4 a.m. on Auburn Avenue playing dice. But many of us have had situations, sometimes life-altering events that were put in motion by small decisions that we made. That if we had chosen differently, if we had gone something slightly differently, it doesn't have to be as traumatic and tragic as this. But in the series of unfortunate events that unfolded that night, culminating in those few seconds, Mr. Beard can absolutely feel like he could have done something differently without being guilty of murder. That doesn't mean he could have predicted this. And Mr. Beard can feel sympathy for the community that lost someone and still have been justified in that moment to return fire and self-defense. Having regrets about that series of decisions that night is human, because it could have led to a different outcome. And of course, he's going to rethink this and replay this in his head. But he can think through that night and think of, from start to finish, all the things he could have done differently, including being in the dice game at all, being on that corner at all, arguing, getting Solo upset, going to the bank or whatever he did, putting the money a different order than it was supposed to be. He can do all of those things without being guilty of murder. So we talked a little bit about the state's burden and how it doesn't change and doesn't shift. It's the highest burden in legal field for a reason, and that's, as you can imagine, because has the most consequences. You don't want to be, you cannot be reasonably suspicious. You can't believe the evidence is clear and convincing. You have to believe beyond a reasonable doubt that this happened, how the state says it happened, and that Mr. Beard was not justified in his actions, his shooting self-defense. I'm not going to hold this up for long, but just 3 shots in the front matches Cedric Jeffrey's testimony, matches Mr. Beard's testimony. High to low, you can evaluate that how you will. 4 fragments from other shootings that we don't know from when. However you felt about law enforcement coming in here, you should be displeased about this investigation. You should be dissatisfied with this investigation. Detective Demeester sat on that stand and told you that he misleads people. That means lie to them. And not just lie to a suspect either. He just lies to people. And the problem with that, neither Car Wash nor Mr. Bailey were suspects when he lied to them and told them that they were probably on camera. The problem with doing that is they don't know that they're not suspects. And so they are very, very pressured to offer information that's not true. When they're being told that they're on camera, they're being told this, listen, you go ahead and tell us because we already know. So-and-so already told us, when that's not true. It's very, very, very muddies the waters between what's the truth and getting to the truth, which is what Detective Demeester's job should be, and just solving the case. So I told you in opening that the state would have a lot of witnesses, and I told you, listen to them for sure.
but they were not there. And their probative values, I would say, limited, given what we heard. So you heard about DNA. Nothing helpful for what you have to decide, but you heard the word DNA and you saw an expert, but it didn't have anything to do with what you have to decide about the shooting. You heard first fingerprints, ballistics, again, we have 12 shots all fired in close range of the dice. Even medical, as helpful as that was, both of those doctors are high in their field, very well respected, but even they cannot show who shot first, cannot show the order of the shots or the position of the people at the time. Now, the state makes a big deal about the fact that Mr. Beard's gun was no longer with him on the police out there. It was up on this 20-foot wall somewhere, we're not sure exactly where on there. But Solo's gun was gone too. Everything was gone. You heard from Mr. Jeffries, this is kind of like a vulture situation. All the money's gone, Mr. Beard's money's gone. And Solo's gun is gone too, but they're not accusing him of throwing it behind the dumpster where it was found. Mr. Beard's being accused of this because he lived, and his gun wasn't with him, it was somewhere else, and so they're saying that he tried to hide it. But this was not a secure crime scene at first, for enough time for all of that to happen. You heard about this. This is a blood splatter, anyways, blood, somebody's blood is right there. And a sample was taken. Whose blood is that? Is it somebody we know about already, or is it somebody who was there and was superficially injured? Just a small amount of blood right there, nobody tested it. These things seem small, but this is accumulation of just poor investigation. For us to not know who somebody who was bleeding at a shooting that ended up being a murder. Somebody was bleeding right there, we don't know who that person is. The judge is gonna charge you, that if you're back there, and you, I don't think the evidence supports this, but if you're back there and you are gravely suspicious that Mr. Beard was the aggressor, Mr. Beard was the one who shot first, if you're gravely suspicious that that's how this went down, that is not sufficient to authorize a conviction, meaning you cannot convict if this is what you. And it's important that you will have this in the back, because it's important that you guys hold each other as you're deliberating to these. You can't just be, well, I don't really know what happened, but it probably was him, so let's just like keep moving. These are burdens of proof that are in the law that we have to follow. Another one that the judge is going to charge you on that is difficult sometimes to accept is that Mr. Beard has an absolute right not to testify. And that cannot, not should not, that cannot be used against him. It's not a suggestion. And so if you're back there and someone's saying, yeah, but I would like to hear from him, no. The burden is on the state, and it doesn't shift him. So if you hear somebody say that, please, this is the law, and the judge is going to give it to you. We raise self-defense through the course of this trial, and the burden is on the state to negate or disprove that beyond a reasonable doubt. Meaning, they can't just prove that he shot, that Mr. Beard shot. They have to prove that when he shot, beyond a reasonable doubt, it was not self-defense.
And the reason that I'm kind of harping on this is because I know burdens of proof, for one thing, we already have, the state has a burden to prove this, but their burden doesn't lessen to disprove that Mr. Beard acted in self-defense. It also has to convince you beyond a reasonable doubt that Mr. Beard was justified. So please don't forget that. It's both. They have to prove the elements in the indictment and disprove beyond a reasonable doubt that this was self-defense. Only would a conviction be authorized if the evidence excludes all reasonable theories of innocence. So not just proof beyond a reasonable doubt, but excludes the reasonable theories of innocence as well. That's law of Virginia. So let's talk about the reasonable theories of innocence in this case. Solo shot Mr. Beard out of frustration, out of anger. Because this was his rent money, he was the bank, Mr. Beard won, and was counting his winnings. That's pretty frustrating, but it makes a lot of sense. Solo shot Mr. Beard because, and you heard all from Mr. Jeffries, the things that that Solo was shouting at the crowd. He didn't like how Mr. Beard was playing. Now, we also heard that at some point the game switched from 3 dice to 2 dice. 2 dice you can cover up the lead. But be that as it may, Mr. Solo did not like how Mr. Beard was playing. Whether it was cheating, whether it was bending the rules a little bit, maybe it wasn't the gentleman's etiquette of this dice game, whatever it was, Mr. Beard, Solo, by all accounts, was the money. Nobody has said in the course of this trial that Mr. Beard was angry. Solo shot Mr. Beard and unloaded that 40 on this dice game because he thought everyone was cheating, as Mr. Jeffries told me, he was yelling at everyone. Or he escalated this cheating situation to be about whatever Mr. Yemen told us yesterday, that all of a sudden he says that he heard Solo shout, "You killed my brother." That's a motive to shoot. That's a reasonable theory of innocence, that he thought that these people in this dice game were somehow involved in some unknown killing. But look who was shot. Dexter Beard, Lee Bailey, Vinnie Martin, and Cedric Jeffries. Nobody in the Ethiopian community that was part of this dice game. So the state says everybody else was armed. We heard otherwise, that other people were armed, including Solo's friends. Solo unloaded on this dice game for some reason. And there are many theories of why. Way more theories than there are Mr. Beard was a shooter. Because the state's theory is that Mr. Beard was winning, Solo was mad, and Mr. Beard, because Solo had shot him, that's not how that works. Solo was mad and Solo shot him first. You don't shoot somebody for being mad at you. He was trying to de-escalate the situation. Solo was mad and hey man, it ain't that serious. Well, apparently he thought it was that serious. The state has already mentioned this charge to you. I'm sure they will probably again. So the judge is going to charge you that the testimony of a single witness, if believed by you, is sufficient to establish a fact. Not you can base a whole murder case on the word of one person, but that the testimony of a single witness, if you believe that person about what they're testifying about that fact,
if believed is sufficient to establish a fact. I'm not sure if the state included this part, but it's in the charge, provided you find the witness's testimony sufficient, you don't have to. This is just saying the testimony of a single witness, if believed, is sufficient to establish a fact, if you believe it's sufficient to establish that fact. That's up to you. A single witness certainly does not prove a case. The state talked about transferred intent. There's no physical evidence, of course, of what bullet hit Lee Bailey, what bullet hit Lee Martin. Was it one of the 6 at max that Mr. Beard could have fired? Or was it one of the 12 that was fired first when they were all together playing dice? You can't find beyond a reasonable doubt that Mr. Beard's gun shot Lee Bailey or Lee Martin, or Mr. Jeffries for that matter. But intent has to be proven beyond a reasonable doubt as to all 6 counts. So the malice murder count, the felony murder count, intent is an essential element of each of those crimes as well. And you would have to find back there that Mr. Beard intended beyond a reasonable doubt. If you decide, if you are to find, which you should, that the defendants, that Mr. Beard's actions were justified, it's not that you can acquit him, but you could find him not guilty if you find that. If you find that Mr. Beard's actions were justified, it would be your duty to find him not guilty, not optional. Even if you don't like it, you took an oath to follow the law. I wanted to touch on this one because some of the testimony that came out about the maybe shadiness on the part of Mr. Beard about the dice game, whether they played 3 dice or 2 dice, whether you could have the money or not. Someone wouldn't be justified in using force if they provoked. What he was doing was not provoking. This was by all accounts, started out as a lighthearted kind of normal dice game. Obviously, Solo was provoked because he did use deadly force. But Mr. Beard, if you believe that he was cheating or coming close to cheating or not being on the up and up about the game, that doesn't justify being nearly shot to death, which is what happened. He didn't provoke that threat, intending to use that as an excuse to harm another person. That's not what that shows, but you will get that charge. We have always maintained that this was a tragedy. It is always a tragedy when somebody dies at a young age. That's all it did. And you are absolutely, completely should feel however you feel about that as well. And your feelings about that are completely justified and related to it. His family, his friends, they lost someone. And this trial is not gonna undo that. But you cannot base your verdict on sympathy. You can feel it. We all do, but you cannot base your verdict on sympathy. So the judge is gonna instruct you before you go back that your verdict must be unanimous. That means agreed to by all, right? So that the ending verdict must be unanimous. But you all don't have to agree on why the evidence isn't sufficient either. You could all have different reasons for finding this just is simply not enough for a murder conviction. So let's talk about examples of doubt in this case. Reason number 1, because you don't know what happened.
Remember those cameras we talked about at the beginning? How at the end of this trial, you were gonna be wondering what those cameras showed because you really don't know what happened. Who was running, who was injured, who had guns. If you aren't clear beyond a reasonable doubt about what happened, you cannot convict Mr. Beard. Another reason to doubt is Detective Demeester himself. He was the lead detective on this case, one of very few investigator law enforcement people that you've heard from. And he stood on that stand and straight up told you that he lies to people. He called it misleading, but it's a little misleading because it's lying. He lied in his police report. He wrote in his police report that Mr. Imam agreed to come to headquarters and agreed to give a statement. That's an interesting way to couch being tossed in the back of a police car in handcuffs and driven to homicide, still being in handcuffs, handcuffed to the floor or a table. He wasn't, couldn't be completely clear about that. And it's not that that Detective Demeester didn't know about that, because Mr. Imam told you that he said, take the cuffs off me, and Demeester told him to chill. Hey man, chill out. Why, what do you have to be upset about? You just got yanked from Auburn Avenue and brought in a patrol car in handcuffs. That is characterized as agreeing to come to the station and give a statement. That's not true. Lee Bailey told you that he was told one person's dead, another person may die, if both die, we're gonna charge you. No evidence Mr. Bailey was armed. Mr. Bailey was just another person who was injured in the gunfire. Police came across him. No evidence he was armed, no evidence he shot anybody. But this shows the attitude of law enforcement when they're investigating a type of case like this in a part of town like this. They are depending on people like you, not caring about people like Mr. Bailey. Another reason to doubt is we don't really have a clear idea of which projectiles were fired when or came from which gun. We have a 9mm magazine. There's a lot of confusion about the guns because Detective Demeester, while he didn't document having gone to see if those cameras worked, he testified to it 7.5 years later. But in his report, he just says it there. He testified that somebody told him they were working. Maybe that's true, maybe that isn't, but he certainly didn't actually go and do investigation. And even by his own account, he wasn't the one to drive the cameras, so they told him that they weren't working. But yet he traced the firearms all the way back to the 70s and didn't testify to you in reverse. He told you the wrong gun, but for the wrong timeline and the wrong person. Richard Hill and Gregory Caldwell. One of them had one gun, one of them had the other. When he testified, he said the exact opposite. It's been a long time ago, but that's how we know he doesn't know what went on with those cameras. He doesn't know if they're working or not, or if somebody told him they were working or not. We talked about how illogical it is for the person who isn't mad to start a gun battle. He was winning, Mr. Beard was winning, Solo was losing, Solo was upset. And it's illogical to put these charges, just like it would have been for Lee Bailey, to put these charges on Mr. Beard when he was retreating. The state's trying to make it seem like he was just running, I don't know, but he was retreating. His car was shot up. Put all of these charges on Mr. Beard, whose gun could only fire 6 rounds at most. There's more bullets than that accounted for in that night. When Solos could fire 14 and did fire at least 12. And the ballistics show, again, where
This was the first round of shooting, and that's why so many people got shot. None of you Solo's friends. And the state argued, tried to minimize the fact that he couldn't get into Solo's phone. Detective Demeester said they could today, they could have leading up to this trial, they could have tried, they have the technology now. But even back then, the GBI could have, the FBI could have. He even said, we've used the Secret Service before, in cases we care about, not an Auburn Avenue case. That could have corroborated or not stuff that was said. It's not an in-house control. It's one more cumulative. We don't care about this case, and we're not going to investigate thoroughly. You get to decide what you care about and what you don't, not the state. We already talked about the tainted crime scene, how the guns and money get gone, lots of people in and out before it gets cordoned off. Mr. Beard said in his testimony that you heard that he doesn't call them crackheads, but they're smokers. And you heard from one of them who admitted to just swooping in there and stealing the cash. You were stealing, the guns got gone, the money got gone. There are people around that were able to clear out a lot of evidentiary valuable things that we do not have. So this tainted crime scene is another reason to doubt. For investigation, overall, there's a reason to doubt, but more specifically, whose blood is on the sidewalk? Whose blood was in the 3 blood swabs that crime scene technician, Mr. Ma, M.A. Ma, he told us he collected for Detective Demeester to send to the GBI. Now, Detective Demeester came in here and said, despite what the report says, that crime scene technician Ma submitted them to the GBI. So either way it goes, we don't know whose blood samples those were, because we didn't get a return on them. Whether they were sent to the GBI, we certainly don't have results from them. What about the projectile from the car, the Bonneville? What kind of gun was that? You guys, one of you guys asked the question. No gunshot residue on anyone? This is a murder investigation. No gunshot residue evidence at all. Another reason to doubt, where's Manny? Manny and Owlet were at the scene that time. We know that. Ms. Casa said Owlet left, but Manny was still there. And she had to have her memory refreshed, which this trial was a lot of refreshed recollections. But she then remembered that Manny was part of the group, was part of the smaller group. Solo's friend Manny was in that group. She never told Detective Demeester about them. A reason to doubt is what would Manny have told you if he got dragged into court the way the rest of these witnesses were and was put under oath and forced to tell the truth. What would Manny, who was in that group of people, actually do about this? About how it happened if he was forced to tell the truth? We talked about Ms. Costa's statement and how Detective Demeester tried to explain it away as she was fearful, even though she herself never said that. She's grieving, she's been traumatized, but she's also heard the streets talking and this community talking, and adopts the version that thinks Solo on that side. The state seems to brush past the fact that Mr. Beard was only shot in the back. Solo was shot 1 time in the back, but he was shot 3 times in the front, but Mr. Beard was only shot in the back when he turned to count money. the y'all killed BG, y'all killed my brother BG, what Kiki with Mr. Young said. It's just one more motive for Solo to have been angry enough to fire on Mr. Bailey, Mr. Martin, Mr. Beard, and Mr. Jeffries. And we're missing other witnesses besides Manny too. We're missing Keon, missing St. Louis, we're missing Botch, we're missing Gangsta. We're missing Dre. Who else fired guns? We don't know anything else about them but their names. Did anyone else have a revolver? It was testified to that it sounded like warfare. It sounded like World War II. Mr. Beard only could fire 6 shots at most. 12 shots probably sounds like a lot, but he unloaded that clip. It's not ridiculous to believe that there were other guns out there. Another reason to doubt is the map just not adding up. The trajectory, testimony, and evidence just not adding up. Basing a murder conviction on shaky eyewitness testimony from 7.5 years ago, from 2014, that's not sufficient, and you don't have to find that it is. It's 2023, we know more, we can do better. And it's your job to hold the state to their burden. If you're back there thinking, this case sure is messy, messy is reasonable doubt. And this case is messy. If you're back there with unanswered questions, which you should be, look no further than the state of Georgia and their table, because they are asking you to convict Mr. Beard of murder based on the evidence that they presented to you. The evidence is closed, that's it. So if you have questions, and not only is what the evidence that they brought to you to prove that Mr. Beard is guilty of murder, they also have to bring that amount of evidence to disprove that Mr. Beard was acting in self-defense. So you have to keep that in mind. It's twofold. They must prove that he is guilty of the shooting and that he was not acting in self-defense, was not justified beyond a doubt. So the state gets to go last, and I'm not going to get another opportunity to address you. And as soon as I go back and sit next to Mr. Beard, I'm gonna remember so many things that I should have said, that I should have said differently. Because you've seen me up here checking my notes, and that's because of that. I'm afraid that I haven't done enough to make you see the truth of what happened that night in those split seconds. Nothing the state says can make up for the lack of evidence. Please remember that. And I trust that you do remember what the evidence was and what it wasn't. And you will not let the state make you forget. Don't let them try to minimize their burden. If you are back there and you think maybe Mr. Beard was the one who was wrong, maybe it wasn't so, maybe it was Mr. Beard, that is reasonable doubt. If you think probably it was Mr. Beard, which you shouldn't based on the evidence, but if you think probably, if you're gravely suspicious, those are they're below beyond a reasonable doubt. And even if you do find that, then you have to find that Mr. Beard was not acting in self-defense, but he was being fired upon. And if you find probably or gravely suspicious, it is still your duty to acquit Mr. Beard. Mr. Beard did what he had to do in those few seconds, and the state has not and cannot prove otherwise. So anything back there, I'm not sure, I don't know, I wonder, wish we had, that is reasonable doubt. your mind is wavering, unsettled, or unsatisfied, for any reason for which a doubt can be given, you must, no, you must find Mr. Beard not guilty. Now, as jurors, you will hopefully remember this case for a little while. The lawyers will probably remember it for a little longer than that. Mr. Beard is going to remember this day for the rest of his life. You decide whether he's a convicted murderer or someone who did what he had to do when he was being fired on. Convicting Mr. Beard is not justice for Mr. Belli. Please do not compound this tragedy by sacrificing another one to it. Do take a careful look at the evidence, use your common sense, hold the state to its burden, and come back with the only verdict that the evidence supports, and that's not guilty on all counts. Thank you.
Thank you, Ms. Feely. Ladies and gentlemen, we're going to take a break, and it can be in two different flavors. It's about lunchtime. If you want to take your lunch break, we can do that. Or we could take a 10-minute break, let you refresh, grab a snack, and your bestie, Ms. Hansberry, could order 4 pizzas from Rosa's that will take about an hour to get here, but we'll have the rest of the closings, and it maybe you go back and start your deliberations before the pizza arrives, and you can actually eat and deliberate as long as all of you are in the same room. We'll talk about those kinds of logistics later. I just needed to get a sense from you so I can let Ms. Hansberry know if she should order up. And they come from Rosa's. I don't know if you've eaten at Rosa's, so it's not, some people like or don't like Domino's. It's a local place off Broad Street. And we typically order, what did she say? I don't get in the middle of it. She usually gets 1 veggie, 1 cheese, 1 pepperoni, and 1 supreme, which has everything on it. And that usually has enough for everyone. But why don't you, maybe you already know what you want to do. Let me ask this. Is there anyone who says, no, I'd like to be able to get out and about and go eat lunch right now rather than take a 10-minute break and then have the rest of closings? Seeing none of those hands, I'll get with Ms. Hansberry over the break. You all begin your break in just a moment. Don't start discussing the case. We're not done with closings, and you haven't had the most exciting part, the law that I get to give you maybe after you've had some pizza. I forgot about that. I need to charge you. So maybe you eat your pizza and then I give you the jury charge, but we'll take care of feeding you. You don't need to worry about that. That will compress the lunch break, which means in the end, you'll get the case sooner, whether I charge you after you eat or we get to that point before the pizza's here. Take a break. We'll get you back in here in about 10 minutes, please. Ms. Ockham, anything before we break?
No, Judge.
You'll be ready to go with part 2?
Yes, Judge.
All right, Ms. Feely, anything?
Dinner.
All right, I'm going to try to be out here just before noon, assuming our jurors are ready, and we'll go. Yes, sir.
Close argument.
We're doing it at 1. We moved all that to 1, and we may make it a little bit later. If the pizza arrives at 1-ish, they can eat while we take the plea, and then I'll charge them. A lot depends on how long part 2 of the closing is. But Ms. Ockham has about an hour left, if that's what she needs. I'll be back out in about 10 minutes. Thank you.
Oh. I will never say.
Yeah. I had a list.
Yeah.
That is true for me.
Yeah.
As a talent.
We asked this specifically.
No, she's the. That's not happening. But I think you need to just see like our relationships that it's not just get right. Because something is nice to live in.
Which one was she? 47. Yeah, the person.
You didn't see me, right?
No, there's softer chair. Yes. That's the part that's. Sure, those sticks, the sticks you're talking about.
I told you, I should have left it for me, but you took it. Those were the cards.
You can demonstrate. How busy?
Let's see. See how I feel. Oh.
What also behind? Shoes off.
I'll call you.
I thought it was six. Yeah.
Okay, see.
I think if I took her shoes off. Geometry.
Well, you see, what a guilty cop.
Where?
Cop. Judge
Oh, yeah.
Halls. Yeah, that was good. Yeah, good. First one.
Who's first?
This the.
Who's it?
Yeah.
Oh,
No,
that's no surprise.
No, there is.
That's good.
John molested, she said, no pops, I could never do it. So.
Yeah, that's what I.
That's what, Just bring stuff here to have it like make it like for fire or something. We have our own kitchen. You'll see reference back.
to say.
Yeah.
There's a. Yeah. Okay.
He's gonna handle her.
No, I think I gotta wear the Chinese clothes. I think I'm too fat to do that.
You're glowing.
Sure.
I do look.
You like these pants? I know they probably have me on. I have to wear this. It's bad.
You're good. I do. And your nose, nothing is extremely. Look at you.
It will. It absolutely will. I know it will. It expands. I just.
Nothing. My fingers.
Oh, really? No, that has no swelling.
My feet, my shoes were tight.
I have no swelling. Thank God.
They moved it to one.
Oh, look at you.
This water tastes funny. I have seen it. Over here. Jesus. Oh, you okay? I need more backing.
No. My goodness, girl.
It's the where it feels. Is Mitchell, please call me because nobody's here. They're all at home.
Everybody's here.
Oh, so I don't think anybody knew.
I, yeah, I didn't know, or maybe I forgot. Yeah, nobody here, everybody.
I sent you the list.
Oh, you did?
I'm
But they just
see if
didn't
there's
call.
numbers mixing. You know what I mean?
Mhm.
That's what I'm seeing.
Mhm. This is it?
That's it. From that date. There was not much visitation.
Oh, really? Which one?
Numbers.
Yes,
Oh my gosh, that's long.
with 10 topics.
Whoa, yeah, that was, I saw that headline. Sorry, I got stuck on phone calls. Let's get Mr. Beard.
She went to grab.
All right, are you ready, Ms. Rivers? Ms. Okam, are you ready for jurors?
Yes, Judge.
All right, throat is cleared. Ms. Feely? Great, let's bring him in, please.
All right, adjourned. Adjourned.
Thank you, Deputy Gordon. You all can be seated. Welcome back, ladies and gentlemen. I received word from Ms. Hansberry. The order has been placed for pineapple and anchovy pizzas are working their way this way. No, it's what I said. But they've been ordered. It'll take a little while just because, not that Rosa's far away, they make them and then I don't know how they get through. They probably have to inspect them at the metal detectors, but they will get here. In the meantime, what remains from closing arguments is what's called the rebuttal or part two of the state's closing argument. And Ms. Okam has told me that she is ready to go. So we're going to give her our attention now.
Thanks, Jim. What I did was wrong. And it's an interesting phrase, right? Because if you're justifying killing somebody, you say, it's unfortunate. I didn't mean for that to happen. You know, he shot at me. You don't admit you were wrong. Because you're wrong when you do something wrong, right? That's when you're wrong. You don't say, I was wrong for killing Solomon Bly because he tried to kill me. Really? He tried to kill me and I'm wrong for defending myself? But that's what he said. I was wrong. You know why? Because he knows he killed Solomon Bly and he wasn't justified. It's not because, oh, I can say he made other decisions. It's because he knew he killed another human being. He killed somebody apparently he claimed he'd known for 10 years. He killed him and he knew he was wrong and he knew he was caught. And that's why he said, I was wrong. Because he was caught in multiple lies. That's why he said he was wrong. Now, we can talk about a few things, but I want to lay down the disputed facts first, right? I've already established that it was June 3rd, 2014. It was in Fulton County, right? Where he was killed. We established that it was over gambling. Said they had gone to 2 dice. We're going to talk about said in detail in a few slides. We'll talk about it. But because said it was 2 dice, they were playing and they can cover up. What did the defendant say? We were playing 3 dice. I was covering my $5 I was covering my $100 bill with the $5. So he thought he would be paying me $5, but I was actually owed $105. Even the defendant said they were playing 3 dice. We were supposed to do everything said says, right? Because said is their star witness. You see every single thing that they said, not what the defendant said, not what Benny Martin said, not what Lou Bailey said, not what Kiki said, but what said. Said he was angry and he was yelling. Said he was saying something. Said he was saying all of these things. Said is our star witness. We'll get to said. There was a lot of money involved. It was $5,000 to the defendant. So let me understand this, right? Because according to defense, it's the street, you know how the street works, the area. So let me understand this. It's $5,000 on the ground, which you have won, right? And the other person is Solo's accusing you of cheating, and the defendant has won it, so it's his money, right? And then Solo is gonna pick up the money he's lost after accusing him of cheating, and he's just gonna let him take it? Really? Based on, well, according to the defense, the area it is, everybody's carrying guns, everybody's big, bad, the man. He's just gonna let you take the $5,000 that they won, that you lost. Can't have it both ways. Either everybody's big and bad, and you can't try them, or you can try them. So in the big bad streets of Auburn and Bell Street, you're just gonna take my money. Even said, when I tried to reach for the fake Monopoly money, do you see his whole demeanor change? It was fake money. It wasn't even real. We were pretending. I was pretending. You saw it was green fake money, and I put it down. And I just tried to reach it. And he was like, and we were role playing. And we are all supposed to believe that there was $5,000 on the floor. Solo was taking the money that he lost. And Death just was like, cool, man. He's taking in the big bad streets of Bell and Auburn streets. Really? Okay. Defendant has a 357 Magnum. Undisputed, because he said it was his gun. Right? And that's the murder charge, unless we're saying now he didn't kill him. Which is it? Because clearly he killed him and he's justifying his killing him, right? That's what they're saying. Can't have it both ways. Either you killed him, and you killed him because he was shooting, or you didn't kill him. You can't say I didn't kill him. We also know there are only 2 weapons, right? Because all of the ballistics matched. There was also these phantom weapons shooting. If there was a 9, you know what would happen? There'd be casings. It would be. Even the defendant admitted it was the 2 of us shooting. Where were all these other people shooting? The Ethiopians were shooting, really? The Ethiopians think their shot. Grady was down to. Everybody ended up at Grady. Even said with the little finger, ended up at Grady. Because it was down the street, but there's this phantom shot person that's dead, that's bleeding enough to the streets, but he just wandered away. So where exactly? Where'd he go? People said walked himself to Grady. But this person that bled on the floor, somewhere, I don't know. I guess on all of the streets, he's on Edgewood, just chill. You go to Grady. The murder weapon was the defendant's gun, undisputed. Solomon Belay was shot in the back, undisputed. He was shot 5 times, undisputed. He lied to Detective Twister, unless we're all going to pretend we're unhearing what we heard the defendant say. I don't want to talk about this. Because apparently now BB is remembering things that she didn't remember in January of 2014, June of 2014, I apologize, right? Apparently BB suddenly mistaken. Okay, so think about this, right? BB told the detective what happened. Prior court proceeding, exact same thing. When she testified, exactly. So she hasn't said it just once, she said the same thing 3 times. First statement, June 16, 2014. Then she says it's in December of 2015. Then she says it's January 5th. She hasn't changed. Everything has been the same, right? Because the truth never changes. Remember what she said? It was sort of a commotion, an argument, and that's what drew my attention. If she had listened to Solo's boys and they had told her what happened, why didn't she know that there was cheating going on? It's gonna help Solo, according to the defense. Why did she say Solo had a gun? And that the black gun was his, and he left the car with the gun? She's helping him, right? She's listening to the streets. Why? And then, oh, she didn't know how much he was drinking. Are we all supposed to forget all of the liquor bottles we saw that was collected? All of those liquor bottles that everybody was drinking, we're just supposed to pretend that didn't happen. So she's lying about the amount of alcohol we drank. All the people were shots, we got them there for hours. We saw all of them. There was Skyline, it was Daniels, it was Epic. They were having a good time gambling. So now she's lying because she's saying we had 1 or 2 drinks before. They ended up at the waiting was handled. Oh, and there must have been a shot. So where were all the people running if the shot had happened? Oh, so they shot and they all just stood there and waited for the garage for everybody to go. Really? She didn't duck down. You hear a shot, you just, oh, I'm gonna chill. Nobody's moving, they're sort of watching these shots happen. Really? For someone that was as scared as she was, that she got in, she ducked down, didn't see the rest of it. If she's going to lie and listen to Solo's boys, make it good. If you talk to them and they told you what happened, you make it good. You don't say, well, I didn't hear what happened because the windows were off. I was just sitting in the car, I was playing on my phone. You tell them the details. You don't provide that he had a gun. Oh, when he left the car, I don't know what happened. I didn't see a gun, I don't know any of that. Don't give all of that to the detective before, because the detective didn't tell her anything. She told him what happened. That's how you know she's telling the truth. So where were all of these other people? The state has the burden. We have the burden remains with us. You know, there's this wonderful thing called subpoenas. I can subpoena as a state. You know who else can subpoena? The defense. And yes, we drag people. Yes, we subpoena people that they talked to, that remembered what happened, that were talked by the detective was trying to find all these people. You know how to subpoena? Excuse me, they,
Which is it?
do you know how to subpoena? You know who else corroborates BB? The physical evidence, what Dr. Sullivan said. You know how we know the first shot was to the back? We'll get to the diagram, because all of the cases were in the same area. So he was down then at that point. Because if you're shooting and somebody's shooting at you, you move, like the defendant did. You don't just stand there and get barraged. You back up, but he didn't. All of his cases were around him where the gambling was, because he was the one that was surprised. Get to the diagram. He was the one that was surprised, because he would have run. Right? If you're shooting at somebody and you see them you back up. You keep moving, as the defendant was doing. He kept backing up, and ended up at the back of his car. But you know who didn't back up? Solo. Because he was the one that was surprised. So all of his shell casings were around him, because he was shooting from the ground. And he keeps saying that the shots were to the front. Well, that's unseen differently. They're all to the side. So he's right-handed, right? And he's shooting, because he's not shooting with the hand of the shot. He told you, right hand on his right. So he's right-handed. We'll get to the diagram. That's all, but he's shooting this way. I mean, was he supposed to be shooting like this? And then how is it downward? Is the defendant shooting up? Because the shot was right here, right? The one to the side is right there. Is he shooting at this angle? All of his hands get, he's talking, he's 5'11". Now let's talk about SAG. Something's supposed to be every single thing said on January 11, 2023. That was the first time they talked to SAG. I was at the poll, I was smoking crack. You know, the second likes to call them smokers, really, on the streets, they call them smokers. Really? What do they call them on the streets? What's the street name? Everybody knows it. Everybody says crackhead, but no, I call them smokers. Think about it. How is, okay, let's use this word, smoker. How is a smoker from the street that does crack in a gambling game that's the pot is $5,000? Where you get money? How is he involved in their gambling? Really, he's right there with the people that are putting stacks, C notes on the ground, $100 bills, it gets up to $5,000. The local, everybody knows smokes crack. The streets has that kind of money, but he's in the midst of a gambling game. Come on. What did they do? It's unfortunate, it's not right. They shoot him away. Throw back up, replaying it. This has nothing to do with it. That's what would have happened. That's why he scurried away to the other side where he marked the X, where he was. Because they were, really, you let crackheads into gambling games that are worth $5,000? That's what we're all supposed to be, when he was just in the middle of it, right there. With which money? Where do you get money from? He's not betting, he's not gambling, but he's, gambling with the big boys. Really? Really? Now we get to the second statement. September 25th of 2015. It's like, he's still at the airstrike smoking crack, but now he sort of sees and hears shots and knows where the person is. Cool. Then we get to December 2022. Third statement. I specifically asked him, I told you to draw where everybody was when the shots happened. Well, it's because, I didn't, I was trying to make space, it was too big, it was any of this. That was mentioned. And we get to the fourth statement, the wonderful one when all, 9 years later, oh my God, epiphany. Remember everything. He was saying, fuck nigga. He was, big bad guy, feeling himself. He was talking, he was doing all of this. And years later, all of this comes to, but then I stole the money. Oh, really? All of these magical things just pop up 9 years later. And there's more. They didn't ask me where I was, that's why I didn't tell them I did any of this. They didn't ask me if he shot him, that's why I didn't listen to what he was like. Lisa said, do you know who shot you? That's not asking you. Is there any other way to ask what happened to your finger? And what did he say? I was at the hole. But sad now, every single thing said says is now true. But BB, because she said, forgot to say how it was there. Everything she says, could have seen it, she could have known it said. Great said, wonderful said. Who admits he was a crack the whole time back then. Everything he says was true. He was in the middle of a $5,000 game. Standing right there. Sure. He's supposed to be back. Really? And if you talk about, oh, crying because this is what they remember, he has told 4 different things at 4 different times and sworn to tell the truth. At least 2 of them. But he's our star witness. Let's believe everything said says. Because, said is such a great truth teller. Talk about Lee Baby. He's been consistent the whole time. I've been across the streets. I got shot across the streets. Every time they ask him, I got shot across the streets. I don't know who shot me, but I seen the defendant with a gun, a revolver. But all that you know is I was across the street. Well, Benny was unhappy. And he didn't want to be here. Lil B was very unhappy with me. It was clear. He was unhappy with the court. Then why is he here? He doesn't want to do this and did it. Doesn't want to do it. He was shot. He doesn't dispute. He doesn't remember anything at this point, right? He says it's so long ago. Remember? First statement was doped up with medication, right? So we tend to that's already impossible there. Second statement, defendant had the revolver back in 2014. He shot Solo. Solo was upset that the defendant was cheating. Remember how everybody knows that Solo was upset because the defendant was cheating, but it only said Solo is mouthing off and feeling himself, and I don't know what is Solo doing. Everybody else, including the defendant, remembers that Solo was upset because he was cheating, but only said, remembers that he was, I don't know, what was this like, popping his collar, showing whatever he said he was. He's the only one that came up with that. You know why? Because he's making things up. But everybody else remembers that it's because of cheating, except our magical said we're supposed to believe everything that he says. Now, the third time was in court, and like clearly he wants to be here, so he has nothing at that point. But this was negates the fact that what he said was that the defendant shot Solo, all hell broke loose, but I was on the other side of the streets, and that's how I got shot. And I ended up, and I ran across the bridge, and that's how I ended up being graded. Talk about Kiki. Kiki ran out of money and he left, but somehow said was in on the boss of the $5,000. Even Kiki left me anymore. They took it all. I was gone. Then I had shots. I came out and I see BB screaming. Right? She's screaming. And I get out and I see her there. What else did he say that was important? I had shots, there was a pause, but I had multiple shots. Keep that in mind. Second statement, I was gambling, lost all my money. I was out of it. Third shots, pause, then more shots. And I saw BB trying to help Solo because I waited until all the shots stopped before I came back out. And I had to do that. Third statement, which is what he said yesterday. Same thing, except he added that they said, and he sort of heard Solo's voice, something about, now, the defense wants us to believe that that's why he was angry, but he spends hours gambling with this people, right? He'd been drinking with them. So much that there was so much liquor bottles out there, and they were the ones involved in the gambling, that mine was like, I was there for hours, right? Because I had to manage every single liquor bottle in a different bag. But he was upset, and that's why, and we learned to do that, didn't. Everybody else says it was 3 days, except you, Magical said. Said it was like, oh, they changed to 2 days. Only him. We're supposed to believe everything he says, when he's lying on every single statement. But the only one I believe is his first statement, because I was right. I was smoking crack, I don't know what happened. I was coming across the street and I got shot, which makes sense. That's actually reasonable. The rest of it, I say no. Common sense and logic, no. Crackheads don't get involved in $5,000 gambling. They don't, because they don't have money. Shane Huggins, why did we call him? Why is he here? Because of the cadence, because it corroborates what Kiki said. I had shots, pause. The defendant shooting, pow, 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 pause. Then his auto, pow, 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 pow. That's how that happened. That's why, because he corroborates, right? And he remembers, and his statement has been consistent because that's what Detective Denise had him saying as well, right? He remembers shots, a pause, then pop, 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 because then the semi was shooting at that point. He's saying, defense has a science and common sense issue. He said, well, the kid, he only had 6 shots, how did it happen? Have we all forgotten that everything was a through and through, except the one that was in Soul's back? And we all know, bullets keep traveling through and through until they come to a stop. You shot weapons, you know this. Almost all of you, boy, I said you shot. Right? They keep going until they hit something. And all his wounds were flesh wounds. What did Dr. Karen Sullivan tell you? It went through, there was tissue. It's only the one in the back that stayed. Even the defendant, when he got shot, his was a through and through. Did he get the bullet? Right? So if it's a through and through and he keeps going, what about Lee, what did he say? Through and through. What did Benny Matthews say? Through and through. So bullets keep traveling until they come to a stop. And that's what they did. They just kept traveling. So this is not a math problem. It is not. No other Ethiopian hits. Okay. I can't. I need to think this through, right? Is it that they're saying that, I'm saying that there are no guns. I'm saying that nobody else fired, is what the state said, because all of the ballistics could be matched. If there was another 9, what do we know about 9s? They're semi-automatics. What do? They leave casings. Unless magical fairies came by and picked up all the 9mm casings, picked up all the other casings of the guns, but because we're believing said he had an extended, oh, I forgot that. Said he had an extended magazine. What happened to our extended magazine this year? And the other guy had a 40. So Clayton was a semi-automatic, so there should be casings, not a single casing found. So they just went around and picked only the casings that were matched. They were not matched to the 40, left only the 40 casings and just sort of disappeared. And Benny Martin told you, so it's Benny, and it's me. You remember, well, something in statements, and the thing about Detective Meester, he told you, every single person I talked to, I recorded it. That's why we have transcripts. Because every single person you talk to, you recorded. So you can't say you didn't say what you said, because you have an audio of it. I guess I can't I can't stop talking about it because it still doesn't make any sense. How did the shot to the back happen? They're running away from somebody and she's shooting. And because we know he stayed where he was, right? Because all of the cases were around him. So we know he didn't run, right? We'll get to the diagram. The evidence, the physical evidence on the scene says he didn't run. Because all the shell cases, you get the diagram and the legend. We're all around right there where the dice game was. So he didn't move. So either he was firing like, well, he couldn't have because he got shot in the butt, so he had to be on the ground, right? That's what the floor. That's be lower than there to get that angle. How was he firing? How? Because he didn't move. He didn't back up, he didn't run, because the cases were all grouped around where the dice game was when he was on the ground, because he didn't have the chance to, he didn't have the opportunity to. How does the defendant get to run and he doesn't get to run? When they're shooting at him, what is he? He's Superman, he dodge bullets, he's gonna stop them, there's a shield that just automatically pops up and bullets just start bouncing off of it. You know what you do? You run, but he didn't, because he didn't get the chance to, because the defendant got the jump on him. And, oh, where's the gunshot residue? Again, we talked about this, you get shot, you get gunshot residue on you. So there's no point, because everybody would have gunshot residue on them. And so are we accusing Lee Bailey of shooting? Are we accusing Betty Martin of shooting? Are we saying Seth is a shooter as well? So all 5 of them shot? It's illogical that Solo was going to take his money. The big bad streets, it was supposed to leave the defense, you can just take $5,000 or just take your money and just peace out, bail, I'm gone. Really? That's what we're supposed to believe. We had no reason to be shot. You get shot for $5. So you're gonna take my $20, I'm sorry, my $5,000 in front of these people, make me look like a chump. In a gambling game where there are rules, the street knows the rules. Don't step to the bank, I'm just gonna let you take it when I'm strapped. Really though? That's what we're supposed to believe? Let's talk about the defendant's words, right? Because we're using words now, because words are important, so we have to believe what they say. The first statement, June 6th of 2014, I went through it. I was coming from the club, my brother was not there, but remember Magical said, there was supposed to be everything that says Dre was there. And it was right by him when they were gambling. I was heading to my Pontiac, shots were fired, Solo was not there, I don't know who shot me, I don't know what happened to my weapon, I'm just, oh my God, I'm in the hospital, I got shot, this is terrible. I don't know what happened to my weapon, oh my God, me, poor me. December 5th of 2015. Now we remember, I was gambling Solo. I was cheating and he admitted, yes, I did it. I was placing bigger bills under the lower bills and he was getting upset about it. He admitted that. I turned back to count my money. Really though? In gambling when all the money's on the floor? I just, turned my back to him and left him there. And that's how I got shot. So what? You're counting the money and he just stoops all the way down with his 5'11" self and then shoots you and then stands back up. And then I return fire and my bullets, magical. They curve, they bend, they do wonderful things. Because that's just how my bullets roll. But by the way, we were the only one shooting that night, just 2 of us. Despite his 40, and I was feet away from him, like right beside him. He only got to shoot me in the back and get any other shots. And I was able to shoot him 5 times. Does that even make any sense? And if it was self-defense, Denise gave him an out. Denise was like, look, if Solo was shooting at you and he did something, just tell me. Because we found 2 weapons. If one of them was yours, just tell me. He even told him to make. I found a 40. I found a 357 revolver. Does it belong to you? Nah, you know why? Because mine's a 38 semi. And I don't remember what happened to it. You don't remember what happened to your weapon? Your weapon? Right. Let's talk about the physical evidence of this great pool of blood that we're talking about and how the gun ended up there. That's the white Pontiac, right? That's his vehicle. It's the girlfriend's vehicle. This is where he ended up, right there. The gun was found directly on the other side of that wall. Right? That's what the gun was on the other side of that wall, right there, because it's beat back from the gun. And he was the one that was like, those are his clothes, right? Because he's the one that ran. And so he's literally trying to get to his vehicle right there. And we know that he was trying to get to his vehicle because there was fragments right by the door, which means Solo was shooting there, right? Because he was going there. And then he gets there, he tries to get in, gets out, because he can't move anymore, because he thought he was going to get away with his vehicle. Unfortunately, he got shot in the right leg's not moving. Can't push the pedal, can't do it. So he gets out of the vehicle and is like, oh crap, still got my weapon, I'm gonna end up in the hospital. And he tosses it right, like, what are the odds? Like, so they're saying, oh, the gun is missing, Solo's gonna end up in a different direction. And you know how we know Solo didn't do it? Because he was dead. So he didn't do it. He's dead. But this gun magically ends up on the other side of where he dropped. But it's somebody else that did it. Wow. What a wonderful coincidence that everything happens just to the defendants. Just him. Only him has magical bullets. Only him that when a weapon is tossed that's his and he doesn't remember what happened to it, it's not him. Just him. Right? Right on the other side of that. Who else would have done it? Who? You travel away from the scene, you just don't toss it, chop it over the wall. That's what you do when you're panicked. You just toss it, hoping that nobody will get to it. If somebody else is taking it and they took it, they would have, scurried away. Then you just, that's what you do when you're in panic. You just toss it over the wall and pray and hope to God that nobody gets it. Unfortunately, it's a power plant, so you know what? Somebody got it. There's nothing wrong with it. We're gonna talk about this blood splatter. Because 54 is the blood splatter, 23, we're gonna use 12, right? I'm gonna use the diagram, right? It's 54, right here. Right? This car is right there. This is Fingertoo's car. I know this looks big, but remember what? There's really wasn't skill and you see the pictures. Right? That's the 14, right? That's 23. These were where the showcase, these were so we know that's Solo's blood. It's not today. That is. This is the only one that was there. So that's Solo's blood. Right? You also know that's the defendant's blood. Like he didn't realize that he was shot because he ran. He didn't hit. So he was in there and then he tried to get into the vehicle across and his legs didn't move. So we know that's his, right? It's gotta be. Who else could he possibly be? We know there was no blood flow, he travel, so he wasn't bleeding yet. He had to be shot right about there, right? Because that's where the fluid blood. The doctor told you but he hit the artery, that was bad after he hit it. It caused a lot of damage, right? And that's why they had to take him back to surgery. So that happened here, so 14, right? So people involved here. So 14 had to belong to one or two people, like Lee Bailey or Ben Moore. And it couldn't have been anybody else because they would have ended up at Grady. Grady was down the street. You don't get shot and end up at a hospital when there's a hospital right there. Everybody got transported to Grady, except said, star witness said, who walked himself to Grady. He walked, he was right there. So this, oh, it's a reason, it is not. That is not reasonable doubt, because all of that is reasonable. Just because you say it's reasonable doubt does not make it reasonable doubt. These are the magical weapons. Where is the evidence of this? Where? Except conjecture, right? Oh, they must have been carrying weapons. Well, maybe, maybe not, but you know what we do know for a fact? They didn't use it. They didn't shoot. Even the defendant and all of this admitted it was only the two of us that were shooting. So this idea that Ethiopians and all those other people that were shot, what happened to them? Where are they? What is this? That is not reasonable doubt. It did not happen. Magical Ethiopians weren't shot, magical guns weren't shooting, magical 9mm weren't shooting, because there would be casings. They were not revolvers. Detective Lisa, I get it. Look, I get it. He said that there were cameras when there were no cameras, and people don't like that. When cops do that, they find it off-putting. It is, it gives you like that, that feeling like, I don't know, right? No, you shouldn't do that. I get it. But that's not reasonable doubt, because you know what? They told Kawash, Kawash was like, yeah, go get the camera. You know why? Because I ain't there. That's what you say. He was like, I wasn't there. I didn't see nothing. I don't know nothing because I was sleeping. Go grab your camera. That's really the same thing. What did he say? Go ahead. Because you know what? I know I was walking. Not that shot. Kiki was dragging me in cuffs. He wasn't happy about it. He did it. But you know what he said? Remember? He said, I need to take it out. He said, because he wasn't in. It was the guy that brought me there, right? And what did Detective Demisa tell you? Everybody had nicknames. I didn't know who was who. I had to ask other people to help me because you heard them. Lil B, Kiki, BB, Sand, Deck, no government names. I didn't know what to start. So you know what I did? I had patrol officers and people kind of sort of help me figure out who these people were because I didn't know them. Right? What did he tell you? I would have loved a surveillance camera. He would have loved it because he didn't have to go back to the scene over and over again, knocking on doors, giving them his card, trying to figure out what happened. He would have just grabbed a surveillance camera, watched it, picked up Deck, and case closed. We had to keep doing all of this because there was no camera. He would have loved it. Because then he wouldn't have to be up running around trying to figure out what happened. Because he would have known, trying to find out who BBs, Kikis, this, that, trying to track all these names down. Because the camera would have shown him what happened. Even after he got the arrest warrant, he kept trying to figure out what happened. He kept calling people, leaving them their names, calling the 911 people. If he was going to mail it, you don't mail evidence like that. Right? That's all you do. You don't spend hours at the crime scene. You don't talk to everybody. You don't orientate everything. You don't canvass the neighborhood. You're going to mail it because of the neighborhood. Frankly, I'm not Detective Demisa, but I'm sure you will find that offensive, right? Because you've been a detective for how many years? You're going to tell me that because of who the person is, I don't care. I don't do my job. I don't do what I'm supposed to do because of the neighborhood. Really though? That's a bit offensive, isn't it? I keep coming back to this because for the life of me, I couldn't stand these magical bullets that the defendant had. But this magical revolver that he had, or that solo was Superman, and what are weapons? And everybody says, I had, well, Kiki and everybody, and Shane said I had boom, 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 we had gunshots, and then he had a pause. And then the semi kicked in, that went pop, 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 wow. This is a semi-automatic, he gets to do that. That's what he gets to do. That's what semis get to do, their revolvers get to do, they get to go fast. Now, this is everything else, this is 1 hour problem, right? We have light, we have the phone, yes, but the phone is irrelevant. It isn't, it had nothing to do with the dice game, what was the phone going to tell you? And they could have opened it, they could not have in 2023, the phone has been dead for 9 years, people. 9 years. And in 2014, they couldn't open the phone, said he asked the family members for his password, they didn't know it, they tried. What were they supposed to do? There was no technology that could do that back in 2014. Thank God we're in 2023, we can do things like that now. We're not back then. And you go, oh, and he told you, once the phone is dead, that's it. And what exactly was the phone going to give you? What? Or, oh, these magically killed kids. Bibi told you what happened. Even Lil B, as unhappy as he was, and I get it. He got shot and he keep asking me to tell the story over and over again. It's all funny, he's upsetting. Even he said the defendant shot. It's still the defendant's shooting. No matter how you cut it or you slice it, or you try to say it's messy, the defendant still shot because of $5,000. And I'm sorry, $5,000 is a lot of money, especially on the streets. It is, and your credit. And these are like people, so then if Solo can just pick up the money, how do you gamble on the streets anymore? If people just say, you're cheating, I'm grabbing my money, and I'm going, how does that work? It's a dollar bill. It is what it is. We would have liked the phone call. If we could have opened it, but we couldn't. And it doesn't change the fact that that's a dollar bill and the defendant shot Solomon Bilal, and he didn't have to. Now I guess we're going to talk about the witnesses. Yes, I'm going to talk about the witnesses because it was the defendant's choice. He got to choose what neighborhood it was, where snitches get stitches. He chose the neighborhood. He chose the location. He decided to shoot Solo on Auburn and Bell Streets. He was the one that decided it. So guess what? We're stuck with the witnesses we have. We have to drag them in because of what the defendant did. They're unhappy to talk to you. What did I tell you in my opening? I said, look, I know Bibi's going to say what she's going to say because she said the same thing over and over again. I know the forensics will say what the forensics is going to say because it's science. They don't play with science. Now the rest of them, folks, this is what they said the first time. This is what they said the second time. We will all find out what they're going to say today. And you know what? It happened. This is what said the first time. Was smoking crack, I don't know what happened. I was at the hole, I came out and got shot. Second time, smoking crack on the hole, came out and got shot. Third time, now we got a diagram, right? Wonderful diagram out, he was here, this is what happened. By the fourth time, ooh, now we're in it. Now we're in the middle of the gambling game. Now I remember everything Solo is saying, and he's popping off, and he's loud, and he's angry, and he's this. Now they're playing two dice. That's how I got shot in my hand, because I was right there. Now we're all hearing at the same time this new version. Told you it was going to happen. You know what? It did happen. We all sat here and heard him say the fourth different story about what happened. Because you don't like Detective Denise and I'm doing it. I get it. It's icky when cops say we have a camera and they don't have a camera, but that's not reasonable doubt. Because you know what, car wash was like, I ain't there, I don't talk about, go ahead with your video. That is not reasonable doubt. That's not what reasonable doubt means. Oh, now the DNA is not important. Calling the toxicologists, the fingerprints are not important. Assuming there was no DNA. Oh, where is the DNA? Why did they print all of the liquor bottles that were there? Why did they test everything? Why did they take everything? They didn't give you anything. They just assumed, they just rush, and here we are. Rush, here we are. Rush, here we are. They didn't even investigate. They don't care. And now that all of that is here, oh, it's not relevant. We don't care about that because it doesn't add anything. It doesn't do anything. It's just nothing. Okay? So, they don't care about the investigation. They do it for hours. Painstakingly putting every liquor bottle, every cigarette butt, styrofoam cup, Q-tip cup, the Sunny water bottle, Red Bull, all of that is an investigation that doesn't care. Leaving there, going straight to the hospital because you want to talk to witnesses immediately after it happens. Following up, going to the vigil, just to see if you can catch anybody to talk to. That's a technique that doesn't care. Really though? That's not invested in what's happening? Just because you don't like that he said that he had a camera when there was no camera, I get it. That is not in any stretch of the imagination reasonable doubt. That doesn't change in any stretch of the imagination what happened that night. That's not how that works.
You've got about 10 minutes.
Again, he was here. This is Solo, right here. So the defendant was shooting this way. Lee Bailey, Benny Martin, and said, despite what he says, they're over here. How did they get shot? But for the defendant's gun. So if the defendant is shooting Solo, allegedly in self-defense, what, Solo is shooting back the same way? And leaving the guy to shoot him? I mean, come on. What are we, 5'2"? They get shot because of him. Solo's dead because of him. He went this way. His car's right here. He ends up here. The gun's right here. How does this not logically and make sense with common sense? That's how Solo ended up dead. Am I gonna sit up here and tell you that Solo was an angel? No. Solo just not, right? Even Bibi didn't take him home, right? Because she has Ethiopian parents. So she went to where he was. She didn't take him to her mama, she didn't take him to her dad. She knew. I'm not saying he's the best, but you know what? He doesn't deserve to die just because he got out of prison. You don't get to kill him. Could he have changed? We don't know. Could Bibi have been a good influence on him because she's also Ethiopian, she has a family, she's in Stone Mountain. Could she have changed him and turned things around? We don't know. We will never know because the defendant killed him. You can't sit up in here and say, oh, he came out from prison and that's how you get to kill him. That's not how that works. You don't get to kill him because he's been to prison. He could have been anything. He could have changed. Bibi could have been the love of his life and told him, taking him back to an Ethiopian family, changing numerous other things could have happened to Mr. Malan. But we'll never know because on June 3rd, 2014, Dexter Beard, aka Deck, put 5 bullets in him. All to the back, all downward, while he was on the ground. He doesn't get to sit up here and say he'd gone to prison after you kill somebody. That's not how that works. He knows he did it. He said he was wrong. The evidence, science and physical evidence says he did it. Common sense says he did it. He doesn't get to walk. What about Mr. Belai's family? They lost their son. What about their family? So because he gets to prison, his life is not important? It doesn't matter? What do we what they're accusing the detective of doing, not caring because he went to prison? Wouldn't that be the reverse of that? You don't get to kill somebody because they've been to prison. He's guilty, finding guilty on every single count. Murder, felony murder, 3 counts of aggravated assault, and possession of a firearm in the commission of a felony. Thank you.
Thank you, Ms. Ocom. Okay, ladies and gentlemen, I have it on good information that the pizza is in the house. Ms. Nelson, I don't know if you've met Ms. Nelson yet, but she's another member of my team. She's down getting it through security, and she will bring it up to the jury room in just a couple minutes. That means we're going to do lunch and then I'll charge you. You don't get to eat pizza while I charge you. It's not all that exciting, the jury charge, but I'll feel bad if you got tomato sauce on your face while I'm telling you the law that you have to apply. So we're going to take a lunch break. It will be a shorter lunch break. We will get back to action as soon as you tell Deputy Gordon we've had enough pizza. We'll save the rest for when we're deliberating. So the flow is break, have pizza, come back. I will charge you. Then you'll get the evidence and begin your deliberations. Any logistical questions? I have a little more logistical information. That means you'll have most of the afternoon to deliberate. We can go past 5 if you want to stay past 5. Depending on what happens today, we may not need to make you come in on Monday, because if all that's left is deliberations and you say, look, we're finishing today, meaning Friday, we just need a couple more hours, it may make more sense just to have you come in on Tuesday. We don't have to disrupt your vacation and crack open the courthouse on a Monday. But we have reserved that ability to do it. So I just want you to know we've got a few options as to the way things will play out if you don't finish what you need to do today. Monday remains an option, but we'll certainly have a good discussion about that towards the end of today, depending on where you are. We'll get the pizza to you. We'll get you back in here when you're done and pick up with the jury charge. Thank you. You all can be seated. No, you don't need me? Okay. I would ask the lawyers from the Beard case to be consulting about what they think goes back to the jury and what doesn't, so we can address that after the jury charge. I have a plea that I need to turn to. Looks like we've got probation and the prosecutor and pretrial all on. I don't know if Mr. Hudson was appearing virtually or in person. He's outside? Great. So let me just see if there's anything else going on with the Beard matter, and then we'll give you guys a break. I'm guessing it'll be at least a half hour. Just don't go far. Ms. Ocom, anything else from the state?
No, Judge.
Ms. Primovic, I got your email, and the language in the charge that is, if you got the hard copy with you now, what page are we on? I believe that the first full paragraph on page 4 sufficiently addresses this question of impeachment, prior statement, conflict between a prior statement and trial testimony. It's not the same language as that pattern charge, but I believe that it legally encompasses it. And so that's the language that I intend to give. I want to make sure you saw that I didn't remove anything. I just didn't add the specific language that you had proposed in connection with prior statements. What would you like to get on the record?
Your Honor, we understand, but we just want to continue, we just want the charge as it is written.
Okay, noted.
Thank you, sir.
You bet. Anything else from the defense? Okay.
1.31.47 for the record.
Correct.
31.47. Thank you very much, sir.
Yep. Right, 1.31.47. Then I would ask if you don't need to clear out from there, you can leave your stuff because you'll be back for the charge and whatever follows from that. But we need space. Actually, Mr. Hudson and his client are going to be at the podium, so don't even move your stuff. It's a plea. So, and Mr. Whitenauer is appearing virtually. Ms. Rivers, are you able to do the plea now, or do you want to break first? Do that now? Great. So if we get Mr. Hudson in here and Mr. Riggins, we'll do it.
Oh, yeah, we were only 30, that's right. We think that yeah, it's the whole thing. That's it, everything else is correct, right? I mean, yes. Yep.
Hey, Mr. Hudson, if you come up to the podium, we'll bring Mr. Riggins out.
No, we just finished. Yeah.
What is going on?
Oh, hey. Those are my. I need to.
All right, we're ready. Just say, just what about this?
Mr. Whitenauer, are you ready?
Yes, Judge.
And Mr. Hudson, are you and Mr. Riggins ready?
Yes, y'all.
All right, Mr. Riggins, I'm Judge McBurney. How you doing?
I'm doing good. How about yourself?
I'm doing well. Thank you for pulling the mask down. It'll help us hear you during these proceedings. Mr. Riggins, you are here today because Mr. Hudson tells me that you are prepared to enter pleas in the two cases you've got in my division. Is that correct?
Yes, sir.
Okay, you are charged in 22 SC 183139 and 22 SC 183141 Mr. Whitenauer, who you can see on the screen there, is the prosecutor, guy in the tan jacket and the striped tie. He's going to swear you in just a moment. Once you're under oath, it's important that you answer his questions and mine truthfully and completely. If you have any questions of your own, let Mr. Hudson or me know. I need to be comfortable that you've understood everything we're talking about. And one way I know you're following it is if there's something that doesn't make sense, or Mr. Hudson said it's going to go this way and it starts to go that way. Yeah, wait a minute. You guys need to explain something. Will you do that?
Yes, sir.
Excellent. Mr. Whitenauer, when you're ready.
Thank you, Judge. Good afternoon, Mr. Riggins. My name is John Whitenauer. I'm an assistant district attorney with the Fulton County DA's office. I'm going to ask you some questions. If you'd please answer yes, no, or as appropriate so that the court reporter can take down everything that we say. Agreed?
Agreed.
All right. If you would please raise your right hand. Do you swear or affirm the testimony you're about to give and the matter pending before this court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please lower your right hand. Please state and spell your true, correct, and legal name.
McKeith Riggins, MakeithRiggins.
And if you would please state your date of birth and your age.
08/21/94 on 28.
Are you now under the influence of any medicine, drugs, or alcohol?
No, sir.
How far did you go in school?
To the long grade.
Okay, you said the 11th grade?
Yes, sir.
Okay. Can you read and write in the English language?
Yes, sir.
And have you had an opportunity to review the documents that charge you in these two cases, that is, the indictments?
Yes, sir.
Do you fully understand the nature of the charges pending against you?
Yes, sir.
So you need to understand that by pleading guilty today, you are waiving or giving up certain rights. I'm going to read those rights to you. And after each one, please indicate whether you understand that you are giving up that right. By pleading guilty today, you are giving up the right to a trial by jury. Do you understand?
Yes, sir.
You are giving up the right to be presumed innocent,
Yes, sir.
the right to confront any witnesses who may testify against you,
Sir.
the right to subpoena any witnesses for your defense,
Yes, sir.
the right to testify and to offer any other evidence in your defense,
Yes, sir.
the right to have an attorney to assist you throughout the trial proceedings,
Yes, sir.
and the right to not incriminate yourself.
Yes, sir.
Again, do you understand that by entering a plea today to these two indictments, you are giving up all of those rights?
Yes, sir.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by a jury?
Yes, sir.
So you're entering a plea to two indictments today. I have to inform you of the sentencing ranges for the charges in those indictments. In the indictment ending 139, count 1 carries a sentencing range of 3 to 20 years in confinement. Count 2, 5 years consecutive to any other sentence imposed. And count 3 is a misdemeanor, and that carries a maximum of 12 months in confinement. Do you understand?
Yes, sir.
With respect to the indictment ending 141, counts 1 and 2, aggravated assault. Counts 1 and 2 carry a sentence range of 1 to 20 years of confinement. Count 3, 1 to 5, 4, 5 years consecutive. And counts 5 and 6 are misdemeanors. Those carry a maximum of 12 months in confinement. And count 7 is a felony, and it carries 1 to 10 years in confinement. Do you understand?
Yes, sir.
All right. Are you now serving any other sentence of confinement, or are you on probation or parole for anything, anywhere?
No, sir.
Do you understand that this is a negotiated plea, which means that the state and your attorney have discussed this, these two cases and come to an agreement about sentence?
Yes, sir.
And that the state will recommend to the court that you be sentenced to 10 serve 2, excuse me, 10 serve 1,
There you go.
balance on probation, with the special condition of no contact with the victim. You attend to complete the family violence intervention program. You possess no firearms. You consume no drugs or alcohol and be subject to random screens. You obtain your GED, and you maintain gainful employment. Do you understand?
Yes, sir.
All right. Do you understand that the court is not required to follow that recommendation? That it can sentence you up to the maximum sentence permitted by law, which I stated earlier.
Yes, sir.
Do you understand, however, that if the court does not accept this negotiation, you have the right to withdraw your guilty plea today?
Yes, sir.
Should the court sentence include a period of probation, you will be required to obey both the general conditions of probation and the special conditions of probation. You will be required to follow the general conditions of probation that probation will give to you when you meet with them, including but not limited to that you are not to violate the criminal laws of any governmental unit. Do you understand?
Yes, sir.
Earlier, I mentioned the special conditions that I'd be recommending to the court. Do you understand that a violation of any special condition could lead to a revocation of your probation?
Yes, sir.
Are you entering your plea of guilty with an understanding of everything we just talked about?
Yes, sir.
Has anyone used any force, threats, or promises which caused you to plead guilty against your will?
No, sir.
Are you satisfied with what your attorney has done for you in this case?
Yes, sir.
Do you have any more questions for your attorney before we go on?
No, sir.
Have you understood everything I have asked you so far?
Yes, sir.
Understanding all of your rights, do you wish to enter a plea to these two indictments today?
Yes, sir.
How do you plead to the indictments?
Guilty.
Is your decision to plead guilty made freely and voluntarily?
Yes, sir.
Did you in fact commit these offenses to which you were pleading guilty?
Yes, sir.
Mr. Hudson, please correct me if I'm wrong, but did you indicate that your client intended to enter an Alford plea under?
Yes, that's what I was gonna say. To the case ending where he was shot, that's why I was gonna ask you to allow him to do guilt on the Alford, but the other case, guilty. Thank you, Mr. White now.
So just so I'm following, the case ending in 139 involves allegations with a knife. The case ending in 141, there's a car, grabbing the steering wheel, choking someone.
That's guilt on the Alford.
141 is the Alford.
Yes, thank you, Judge.
Okay.
Mr. Riggins, with respect to the indictment ending 141, are you entering your plea of guilty pursuant to North Carolina v. Alford, meaning that you may not admit guilt to every element of the crime charged, but believe it's in your best interest to plead guilty today?
Yes.
With respect to indictment ending 139, did you in fact commit the offenses in that indictment?
Yes.
All right. And sir, are you a United States citizen?
Yes.
Sir, if you wish to challenge this plea for legal error, you have one of two ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file a direct appeal. The second way is a habeas corpus petition. For the felony counts, you have 4 years from today, and for the misdemeanor counts, you have 12 months from today to file a habeas corpus petition. Do you understand these time limits?
Yes, sir.
Do you understand that you are not allowed to possess a firearm during the course of your probation?
Yes, sir.
Do you understand that if you were found in possession of a firearm, you could be charged with another felony, which carries up to 10 years in confinement?
Yes, sir.
Thank you. Your Honor, if first with respect to the indictment ending 139, if that case were to proceed to trial, the state would prove beyond a reasonable doubt that on or about April 12, 2021, officers with the Atlanta Police Department responded to 2500 Center Street in Atlanta, which is located in Fulton County. There they encountered the victim in this case, and who is also the victim in the second case, Miss Akeria Payne. That's A'*KERIYAH Payne, PAYNE. Officers in speaking with Miss Payne learned that she and the defendant, Mr. Riggins, lived together at that location, that Mr. Riggins had come to her that day and asked to have sex, and Miss Payne declined. After that, Mr. Riggins proceeded to go through her phone and on her phone, Instagram, where he found a conversation where she and her sister and her baby's father were apparently talking negatively about Mr. Riggins. That upset Mr. Riggins, and he then began to punch Miss Payne in the face with a closed fist. Mr. Riggins also charged at Miss Payne with a kitchen knife, causing cuts to her left arm. After that initial altercation, Mr. Riggins allowed Miss Payne to sleep, but then she was awoken about 2 hours later with him again punching her in the face, kicking her, and stomping on her head. She fled to the leasing office. Officers, while speaking to her, did observe visible injuries to her eye and also a cut on her left arm, scrapes and bruising to both her arms and her left side. In speaking with Ms. Payne further, they learned that after this second altercation, she left the apartment and went to the leasing office, where she waited for officers to arrive. While she was waiting, Mr. Riggins came to the leasing office and stated that he needed to get his sister's key. The agent that was on duty asked who his sister was, and he responded, Akiria Payne. The agent lied and said she would go get it, hoping to stall him. However, he left before officers were able to arrive. When they did arrive, in addition to taking Mrs. Payne's statement, they also offered to escort her back to the apartment because she expressed fear that Mr. Riggins would return and kick in the door, adding that this was not the first time that Mr. Riggins had been physically abusive to her. Your Honor, that incident was on April 12, 2021. The defendant was arrested on March 26 of 2022. And he was released 4 days later. The second case, the indictment ending 141, occurred just 2 weeks after he was released from the Fulton County Jail. It occurred on April 13th of 2022. On that day, officers with the Atlanta Police Department were dispatched to a report of a shooting. They arrived at 2535 Center Street, which is also located in Fulton County, and encountered the defendant before you, Mr. Riggins, on the ground, and observed that he had apparently sustained one single gunshot to the midsection of his abdomen. When asked what happened, he stated simply, "My girlfriend shot me." Witnesses on scene stated that they did not witness the shooting, but they did see a gray in color sedan leaving the scene with a flat tire on the driver's side. That vehicle was actually captured on surveillance, and you can see it pulling up to that location and Mr. Payne exiting from the driver's side, the passenger side of the vehicle, walking briefly to the rear of the vehicle and then laying down in the street. You can then see Ms. Payne exit the vehicle from the driver's side, walk around the rear of the vehicle, look at Mr. Payne, and then return to the driver's seat and drive away. While officers were on scene, a witness was able to identify that the girlfriend was Miss Akiria Payne, the victim in this case. And they were able to then, they were able to go onto LPR and look for the vehicle. They were able to find the vehicle, and they began trying to track it. They found the vehicle in the area of Hamilton Homes and MLK. An officer conducted a traffic stop on the vehicle, and Miss Payne was in it driving. She also had with her and her 5-year-old daughter in the back seat. The officer who investigated this case changed locations to go meet that officer and Miss Payne, who had been detained, and spoke with her after reading her Miranda rights. She explained that she had gotten off work at 11 p.m. from McDonald's on Riverdale Road that day, and that Mr. Riggins began to call her cell phone numerous times and cursing and threatening her. She recalled him saying things like, "Bitch, where you at? You out here being a hoe, and you got me fucked up." She advised that he threatened her over the phone, saying words like, "Watch when I see you." She advised that as she continued to drive on her way, she observed that Mr. Riggins was then nearby, and he began to pull on the door handle of her vehicle, banging on all the windows, and that's when she became scared and locked the door. He then began to throw a brick through her window and she unlocked, or excuse me, he began shouting, threatening that he would throw a brick through the window. At that point, she unlocked the door and he entered through the passenger side door. At that time, he had in his possession a silver and color firearm, and he placed it between the passenger seat and the center console. At that time, once he was inside the car, he began strangling her with both of his hands around her neck. Ms. Payne went on to say that she feared for her life and feared that she could die because of the rage that Mr. Riggins was in. And while she is trying to drive, she tells the officers that she's trying to grab her phone to dial 911, but he snatches it out of her hand, that he punches her in the face with a closed fist, and that he grabs the steering wheel and tries to run the vehicle off the road, which would explain the flat tire that was observed by witnesses on scene when Mr. Payne exited when Mr. Riggins exited the vehicle. In jail calls, Your Honor, I'd note that Mr. Riggins attempts to downplay what happened on this date, and Ms. Payne, for her part, pushes back a bit, noting that he was pulling on the steering wheel. So she's been consistent, at least on that one detail. I'll speak more about Ms. Payne in a moment. So finally, she arrives at 2535, where officers first reported to. And at that location, he is punching her still in the eye with a closed fist, that he is doing so while holding her hair with his left hand and punching with his right. And at that point, she grabs the firearm that Mr. Riggins had placed in the vehicle when he entered the vehicle, and she says that it discharged. She denied that she pointed it or that really aimed it at him, but that she did grab it and that it did go off. At that time, Mr. Riggins did exit the vehicle, saying, "You shot me, I'm about to die." As I indicated earlier, she also exited the vehicle to try to help him, but panicked when she saw a vehicle approaching and left. She dropped the gun while she was running behind that vehicle, but she picked it up and put it in the trunk of the vehicle. And then after this altercation, then went to pick up her daughter, and also while officers were looking for her, changed the tire on the car. Ms. Payne explained that that they had been together for 2 years with no children, that she keeps going back to Mr. Riggins because he gives her money. Officers observed on Ms. Payne a black eye, a busted lip, scratches on her neck, and a swollen right wrist. Officers did find in the car one spent casing on the passenger side floorboard and a gun in the trunk that had been reported stolen out of DeKalb County. Your Honor, we've not yet had an opportunity to speak with Ms. Payne, but I think there's a reason why, and that's because the defendant has been calling her consistently while he's been in the Fulton County Jail, and has been encouraging her to recant, using poorly coded words. On one occasion and one call, he told her to tell them, referring to our office and the prosecutors in the office, that you, quote, don't want to go through with the house, unquote. On another occasion in a different call, he told her, quote, I need you to iron the clothes, unquote. So, Judge, that's the factual basis for these two cases. The defendant does have convictions under first offender back in 2013. The court consolidated 3 separate cases into one plea. There's 13 SC 120105, that was for burglary in the first degree. 12 SC 114307, that was burglary in the first degree. And then 12 SC 113248, that was criminal attempt to commit burglary. That was reduced to disorderly conduct. On those first 2, the defendant was sentenced to 10 years to serve 1. The judge, writing in the sentence sheet, commuted to time served. And on that third case, 12 months to serve, commuted to time served. Judge, the defendant has been in this most current stint for 263 days. He also, Judge, while he's been in the Fulton County Jail, has picked up another felony case. It's unindicted and pending at 22 CP 211585. It occurred in June of last year. That case is pretty straightforward. It's proven by jail calls. The defendant attempting to extort another inmate for money. It was our intention to have that case indicted and disposed of today, but I did not receive a waiver in time to provide that to the clerk's office and have an accusation with SC number today. In any event, Mr. Hudson has indicated that he did want to proceed with the plea on these two cases, and there's nothing further from the state.
Do you have a sense, Mr. Whitenauer, as to why the plea in 141 is an offered plea? I'll hear from Mr. Hudson in a minute, but I'm curious to your perspective on that.
Yes, Judge. So without the benefit of being able to speak with Ms. Payne, but from having from conversations with Mr. Hudson, I understand that it's Mr. Riggins' position that Ms. Payne was actually being the aggressor in that instance, and I suppose it'd be best to allow him to elaborate on that.
Okay, thank you so much. Ms. Jackson, good afternoon. How many cycles does Mr. Riggins have?
6 cycles, Your Honor.
And I heard about the one conviction, I guess it was a first offender disposition that was a consolidation of 3 cases. Any cycles more recent than that, other than these 2 cases?
No, Your Honor.
Okay, thank you so much. And Ms. Tucson, how is it that, I guess if it was 2013-ish, maybe those cases are closed. That first offender case has wrapped up?
Yes, Judge, that one ended, it just ended October 30th of 2022.
Look at that. Okay, thank you so much. Mr. Hudson.
Thank you, Your Honor. Present before me is Mr. Riggins. He's 28 years old. His mother, Sherry Williams, and his sisters are present in court. Judge, I'm gonna start with the easier case first. The first case, that's a guilty plea. That is exactly what happened. We're not trying to explain it. Those two, Ms. Payne and Mr. Riggins, have such a toxic relationship back and forth. As far as the jail calls, I agree, Mr. Whitenauer. I've talked to him at length about the case, so I've got to know Mr. Riggins about communicating with her, and he knows that I think he hasn't been in touch with her recently, but this was early on. I want to address the one that's an alpha plea, and here's the reason why. Judge, first of all, I want to thank Mr. Whitenauer because I gave him evidence to support my claim. Ms. Payne, it's our belief she doesn't want to talk to the state because it's more to the story of what happened. One thing I can agree, because if I tried to argue this in front of you, Judge, you wouldn't have gave him a bond, in which because of his previous record. But the good thing about it is this actual crime occurred on video, and it shows where she's driving in a straight line. Now, if he was choking her, Judge, the car would have went all kind of ways. She actually shoots him with the gun, gets out the car like Mr. Whitenauer described it to a T, looks at him, he's wallowing in pain. I think he lost half his spleen or something like that. He had to spend a lot of time at Grady. She jumped back in the car and does everything that Mr. Whitenauer describes in the rendition of the report. Also, Judge, this is another reason why I believe it's a Alfred plea. The same gun that she described that Mr. Riggins had, we provided the state with pictures of her Instagram, where she actually got the gun tucked in her waistband. The exact same. So it wasn't Mr. Riggins' gun. He did beat on the window. He did maybe threaten it, throw a brick in there to talk to it, but he'd never thrown it. She let him in and she had the gun. Because what is believed, she wants the state to believe, is that he came in there with a gun, put it in the center console, they get to arguing, she drives off and shoots him with his own gun. That did not happen. They got to arguing. It could have been pushing and shoving, Judge, but it didn't look like it. But she pulled out the gun and shot him. And she, like I said, she gets out the car, looks to see him in pain. He doesn't jump out and say, he shot me. He shot me. Mr. Whitenauer can show that the fact that it can even testify to on the video. He jumps out the car and falls to the ground, like wallowing in pain. And some bystanders come about. And she actually get out the car. She looks at him. And then the bystanders come pull up. Well, when she see the bystanders pulling up, she jumps in the car, drives away, and they help him. But Yana, those are the facts. That's why I asked, it's likely under a jury could possibly find him guilty, but Mr. Riggins wanted to resolve this. And I appreciate the state because the initial offer was 10 served too, but Mr. White now had an open mind to see the facts of this case. As far as the other case in 2021, Judge, I have nothing to say about that. My client, like I said, he need to make better decisions. He's not going anywhere, Judge, even if you follow the negotiated resolution. That case is still on no bond status, and I'd rather address that. And Mr. White, now I did file a waiver with the courts today, so all you have to do is accuse it whenever you get time to it. So it's actually been filed, but that's case still technically in non-complex. It's a CP case, so we don't need to address it. But Judge, I just ask that you follow the recommendation. Like I said, he's been in jail for a little bit over 270 days. His family is present. They're ready to reunite with him. He doesn't live on Center Street in the Roland B&W Way apartment complex. He have no reason to be over there. He doesn't talk to Ms. Payne, so we'll ask that he have no contact with Ms. Payne, and all the other conditions that Mr. White now pointed forth, we are in agreement with.
Okay. And Mr. Riggins, you don't have any kids with Ms. Payne, is that correct?
No, sir.
All right. Do you have any questions about anything anyone has said so far?
No, sir.
Anything you want to add?
No, sir.
What was the damage you sustained from getting shot?
I don't have no gallbladder. I got a piece of liver. I don't have a spleen. I had 4 broken ribs. I was in a coma for like a week and 2 days. Had to get 4 blood transfusions. I lost a lot of weight. I was like 89 pounds when I got out of Grady.
All right. So you lost a lot of your insides.
Yes, sir.
Okay. Sorry to hear that.
Still be suffering a little bit from pain in my stomach from time to time.
Okay. Sounds like you and Ms. Payne had a complicated relationship.
Yes, sir.
I'm glad you're still alive. I'm glad she's still alive.
Yes, sir.
Hopefully she's going to stay away from you. I know you're going to stay away from her. Mr. Riggins, I find there's a factual basis for your plea in both cases. The case ending in 139 is simpler for everyone. You're telling me, yep, I did it. I got angry. I shouldn't have. Could have been you guys were both arguing with each other, but in the end, you took it too far. The other case is more complicated, and I hear you loud and clear through your lawyer that you disagree with the version of events that Ms. Payne gave. But the reality is, given your situation, especially given that everything that happened in the case with the knife will come in at trial for the case with the gun, that a jury, if Ms. Payne continued to tell that version of events, the jury could believe her and not you, and could find you guilty of the other case, hence the Alford plea. And I'll accept it as an Alford plea. I also find that your plea is knowing and voluntary. Voluntary means no one's forced you to do this. You've decided after consulting with Mr. Hudson and your family that this is the right way forward for you. It's in your best interest. Is that correct?
Yes, sir.
And you've told me by saying you have no questions that your plea is knowing, meaning you understand things.
Yes, sir.
I'm sentencing you pursuant to the Probation Options Management Act, and all that means is that while you're on probation, which you will be once again for a while, if you have a small or a technical violation, you and probation sort that out. You don't have to come see me. But if it is a violation of the law, you get arrested again, or of any of the special conditions I'm going to give you, the main one of which is stay away from Ms. Payne. You violate any of those conditions, that comes back to me. All right, here's the sentencing get the calendar back up here. In 22 SC 183139, I'm sentencing you on count 1 to 8 years to serve 1 year with the balance probated. You'll get credit for time served. Let me do different math. Count 1, I'm sentencing you to 3 years to serve 1 year with credit for time served. So you got some more time to serve. Count 2 has to run consecutive, and that'll be 5 years, and that'll be probated. Count 3 is a misdemeanor, and that'll be 12 months to serve concurrent with count 1. So the overall sentence in the case ending in 139 is 8 years to serve 1 year, credit for time served, balance probated. Special condition number 1, no contact with Ms. Payne. That's no direct contact. You don't call her, you don't write her, you don't put something on her Instagram page, but you also don't do it indirectly. So if you guys have friends, you don't work through them to let her know you're sorry or you're mad, you're going to get her or whatever. If she brings evidence to the state that you were contacting her, They're going to bring you back in here and I will revoke a big chunk of that probation because the main thing you need to do is leave her alone. Now, she needs to leave you alone as well. This is not meant to be a trap. If she is texting you, save those, don't respond. Do not respond. Get those texts to Mr. Hudson because he can get in touch with the state and say, look what's going on here. You need to know there's some honey baiting out here. So just be real thoughtful. You don't do any outreach, but you also can't respond if she's reaching out. Hey, I need some money. I'm so sorry. I miss you. Whatever she might say, go dark. Do not respond. You respond and she saves that. I can't help you if you've responded. But I can certainly get in the mix to say, if we ever find her, Ms. Payne, you need to leave Mr. Riggins alone. Okay. You will need to complete what's called a family violence intervention program. That's a series of classes that'll help you work through your relationships with women in a way other than grabbing a knife or doing whatever you have done in the past. You'll be subject to random drug screens while you're on probation, and you'll need to get your GED. That doesn't mean right away you got to go get it, but you need to be enrolled. And in fact, if you're not enrolled within the first 6 months of being on probation, I need probation to send that back to me. Any reason you need to be at that apartment complex on Center Street? What's it called?
Rolling Beans.
It's got a lot of different names.
Is it Etheridge
Etheridge
Court?
Court, right.
Etheridge Court, Rolling
Yeah, so don't be there. That is, I guess so many cases from there. You go there, you're just gonna get snapped up for something anyway, even if you're just kicking it there. Like, you know what? That guy had dope, we're gonna grab everyone. So you stay away from Etheridge Glen, Roland Bend, the 2500 Center Street. You know what I'm talking about. Don't be there. If the police bump into you there, you violated your probation.
Yes, sir.
Okay. And someone in your family really likes that condition. You're getting a lot of nods from someone in your family
That's his
saying
mom.
your mom
Please.
wants you to stay away from Etheridge
She's been
Court.
trying to tell him to stay away.
Yeah, Etheridge Court. I can't tell you how many cases I've had. How many cases Mr. Hudson's been representing? So I'm like, I know my client should have been at Etheridge Court. All right. That is the first case. Second case, 22 SC 183141. Counts 1 and 2 and 3 are all 3 years to serve 1 year with the balance on probation. Count 4 has to run consecutive. That'll be 5 years consecutive to count 1. Counts 5, 6, and 7, 5 and 6 are misdemeanors. There'll be 12 months to serve concurrent with count 1. And count 7 will be 3 years to serve 1 year, and that'll run concurrently with count 1. So the sentence in the case ending in 141 is also 8 years to serve 1 year. You'll get credit for time served, and the sentence in the 141 case will run concurrently with the sentence in the 139 case. So overall, it's 2 different convictions. One is an offered plea, but that's still a conviction. The other is a regular old guilty plea conviction, but there's no more first offender. You're now a convicted felon. That makes it harder to get work, but you used up your first offender. You actually got 3 cases rolled into 1. But your overall sentence is 8 years to serve 1 year. You'll be doing a little more time. When you get out, you'll have 7 years of probation. I don't think what was negotiated was unreasonable. If you and Ms. Payne are gonna get into it again, I don't need to wait 8 years on that. That's gonna be in the next 6 months. That's gonna be in the next year. I'll see you and I'll revoke you if you've done something to Ms. Payne. The other stuff is just, it's helpful. You take in the family violence intervention program, you get in your GED, move forward with life, do something different than whatever was going on with you and Ms. Payne. So the same conditions that I mentioned for the case ending in 139 will apply to the case ending in 141. So you got the same conditions of probation. You're really only one probation officer. It's just 2 different cases with simultaneous sentences. Mr. Whitenauer, anything I didn't include that you want me to include? I know I didn't mention things all the way through. I'm not requiring him to work. He needs to work, but I'm not going to require that. Anything else?
No, Judge.
Okay, Mr. No questions.
No, just want to say thank you.
Okay. Last thing, Mr.
Thank you.
Riggins, do you authorize my staff to sign the 2 indictments indicating your guilty plea and your offered plea?
Yes, sir.
Mr. Hudson, can we sign for you?
Yes, Your Honor.
And Mr. Whitenauer?
Yes, Judge.
All right. you're gonna need to talk to probation. Well, no, Ms. Tucson, Mr. Riggins is not gonna get out right away. So you can tell him what you need to tell him, but he's not gonna be reporting in the next few weeks. So share with him what you need to. I think I've covered everything I need to. Do you have any questions before we hear from probation, Mr. Riggins? Any questions?
No, sir.
Okay. Ms. Tucson.
Good afternoon. Do you know where probation is, on Memorial Drive?
Yes, ma'am.
Okay, I'm gonna just need a good address for you, and then when you are released from custody, just go ahead, and report. Lexington Avenue, is that correct?
No.
No, ma'am.
No, his mother sent up Ms. Williams. Your Honor, speaking to Sherry Williams, Ms. Williams, can you give his address?
Yes,
Please,
I
ma'am.
can't get county, but he can get my mom's address, it's 2131 Pryor Road.
2131 Pryor Road in Atlanta, zip code 30315. Did you get that, Ms. Tucson?
2131 Pryor Road, 30315. Just make sure you report within 48 hours, then, after release. Mr.
Did-
Riggins, they can do your, intake again, okay?
Yes, ma'am.
Did we get the wrong street address?
2131 Pryor Road.
Yeah, 2131. Yep, we got that. Excellent. All right. Thank you, everyone.
Thank you, Judge.
Thanks, Mr. Whitenhour.
Thank you, Judge.
Thank you, Ms. Tucson. Thank you, Ms. Jackson. You guys have great weekends.
Thank you, Judge, you as well.
Thanks, you too.
Thank you, Judge.
You bet. Are they still eating? Okay. Check, but I'm going back there and we need to give Ms. Rivers a break too. I just want, if they say, hey, we're done, we'll let them know. It's not quite yet, because we were doing this, but I'm gonna go take a break.
They were done?
Huh?
They were done?
Yeah, it's how I'm here.
Oh.
Anyway.
Okay.
we too far away here to print on powder?
So yeah,
Are we too far away?
no, you can do it at your house.
What I thought, but
There's been a problem of carrying it for this one. It should just go right to it.
I just turned on this and materials.
You do the file, you do the process.
I didn't read that one, I just ordered it. Did you say this one back? You say which one back?
So, practice. So we put the whole ball.
Yeah. You can't go back to the off.
No, that's that right there.
There's nothing, it's running.
So I have blind Bill, and so because he can't judge um, um, the new judge. Mhm. So that's what um, yeah. What do you think? I was in the, maybe, I was in before you. Oh, before I came here. No, Melissa, was not.
Looking for the court reporter.
She's, or she's got to focus on her. I.
Waiting in line to get rid of buildings. Okay, yeah, it's gonna be not crowded. Yes. I heard that you need
Oh,
it, but
I-
that's- I don't think so, like, the name. To come up.
No, they're still.
I thought I missed some.
No, they're about to come back in.
Oh, hey.
They're gonna come back
Nice to
in.
be done. They coming back? Good job. Hilarious. I'm sending her. It's for, oh, God. Can you show us the banana too?
So cute, I love you, soldier, you're like, I just eat straight protein.
No, I mean, it's just one of those, you know. the-
Disgustingly healthy.
Like, I just.
You were hard on her. I was hard on her.
I want to introduce myself, I'm Sears, I did the motion for the trial.
Oh,
Mr. Beard, I don't know if he's on my name for the record.
yes, Sinead Kuoka, nice to meet you.
Nice to meet you too. Nice to meet you. I haven't been in the criminal world in a while, so
Really?
there's some changes.
Where'd you come from?
Well, I went to civil practice, so.
Isn't criminal law more fun?
There's nothing compares, like, I think my colleagues are always like, why are you always talking about criminals? You know, it's just, there's nothing like it. It's so much boring, so much more boring. You're just arguing over money damages, you know, I think torts now. But it's funny, I do trials, so it's different, so I did it for appeals in the PD's office. So now I'm a trial attorney. So that's good. Yeah.
You don't miss appeals?
Cause I tell people that are nice, like to write, they don't like to try.
And people that try, like
I
to
think
write.
that's a little different. I like to just have a very broad practice and do everything, you know. As long as I'm in court, so I'm happy. What are you looking at? I stand by everything I said, YouTube. Hi, YouTube.
YouTube hates.
No, I stand by everything I say.
I stand by everything.
This is another change in the courtroom.
Oh, I think it's just
it's really
judgment
just
learning.
him.
Oh, okay.
Just him. Nobody else has it on you.
No, seriously, it's just.
It has been helpful for me because I haven't been able to be here. So it helps me tune in.
Yeah, to tune in.
This is like if you walk this out.
I know, or to log into the Zoom
Yeah,
and give it to family without having to.
I heard what the judge said about the Ninth Circuit, having the one juror not even there.
How do they allow
Defense
that?
agreed.
Yeah, so
You
that's
can't
like,
go back
that's
to
called
the-
an invited error, or, you know, what, if you're gonna say it's error, then the other side said you invited the error.
You can't say it's error though, because you agree they asked.
Yeah, no,
Where
it's
do you
not.
work now?
I work at a firm called Nolan Miller, civil litigation
Oh, yeah.
defense.
Uh-huh,
You know them?
yeah, I do. I was civil too. at
Okay.
one point. I worked for, so many different defense firms, but Gunn McCaffrey, Gray Russ.
Okay, okay, cool. What do you like better?
Oh, criminal,
Absolutely.
absolutely, absolutely.
I was wondering if Kevin Armstrong might show up, you know, United Cross Boards on his case on appeal. Yeah.
Yeah, but sometimes.
I'm gonna text him. He's still in your office, right?
Yeah, absolutely. He's the head of,
He's the head of appeals now?
Yeah.
Okay, that I saw.
He's basically like Laura Chico on their side.
Yeah. I saw him.
He's in the YSL trial, on the defense.
Yeah, I do have another.
I still do. Mark Mallon, I don't know if you guys knew him, but he was an
He's been there
appellate.
he's been in DA, I don't know, 20 years.
Oh, really? Now he's at the defense table?
I cannot wrap my brain around it.
That's funny.
He's like a
He's
diamond.
always very, passionate.
Yes.
Yeah.
Yeah,
There's that, somebody named Mark.
yeah.
It's not one, it's such a.
Is he here today?
I didn't see him, sorry, I saw this with
Yeah, I asked him when he said he was filling in for Ed Adams. Who was at the game. Yeah. Cause I guess that's more important. To the people.
Oh, really?
Okay.
Yeah. So you,
Yes, let's talk
I
about
mean, we should show you what.
Oh, he's been at that job.
Oh,
Yeah, he's been there forever.
I thought we.
He's been there. Switched into his new role. Yeah. He does? Yeah. He probably did a second job.
Yeah,
Because you know he only works for
I know you said that.
like he has to go get his. Yeah.
Yes.
Yeah, we. Mhm. It says in the first one. Yeah. Yeah, they will. Because they can hear. No, I just have like, when I sit down, it's like, what are you doing? This is not happening so well. I think I'll probably. I don't know, I guess. I got 4 more months. I think mine in 2 weeks, so I'm 4.5. Dylan. What do I? A girl. I don't know what I'm doing. I don't know what I'm doing. Oh, which is not great. You still just wake up. Yeah. I don't have it. It is what it is. Yeah, gently. Yeah. Yeah.
What kind of water, man?
Ms. Rivers, are you ready? Ms. Ocom, ready for the jury charge?
Yes, Judge.
Ms. Feely?
Yes, sir.
And we have Mr. Beard here, so we can get started. Let's bring the jurors in, please.
All right, the jury.
Thank you, Deputy Gordon. Everyone else can be seated. Welcome back. How was lunch? Excellent. Don't thank me, thank yourselves. But appreciate folks staying in. I had to take a plea, work on a couple things with the lawyers, but we are now ready. I am now ready to give you the law that you must apply to the facts as you find them to be. Let me explain the process. I will be reading to you from this document. This is the jury charge that applies to the case of State of Georgia versus Dexter Beard. So for those of you who are good listeners, you'll hear me say all the words in this document. For those of you who like to see what's being said, there won't be a bouncing ball, but as we go along, this works. You'll see the words I'm reading are on the screen here. So you'll be able to follow along that way. But don't panic if you start to halfway through say, it's just a lot of words. You get this document. The thing I'm reading from goes back to the jury room with you, along with the indictment, all the evidence, and the verdict form that I'll talk about in a little bit. So please do follow along. Don't need to take notes. You're welcome to, but you'll get this document to review should you need to. If there are any questions about it. And again, this is the law that you must apply to the facts as you find them to be. A grand jury has indicted the defendant for murder. Let's see if I can read this better. It's got pictures in the way. There we go. Felony murder, aggravated assault, and possession of a firearm during the commission of a felony. The defendant has entered a plea of not guilty. The indictment, which is right here, and the plea, the not guilty is actually written right on it, not form the issue that you are to decide. Neither the indictment nor the plea of not guilty is evidence. The defendant is presumed innocent, and this presumption remains with him unless it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of one or more of the crimes charged. The state must prove beyond a reasonable doubt every material allegation of the indictment and every essential element of each crime. And I'll be giving you the elements of the crimes in a little bit. There is no burden of proof upon the defendant, and the burden never shifts to him to prove anything. If a defense, like self-defense, is raised by the evidence, the burden is on the state to negate or disprove that defense beyond a reasonable doubt. The state is not, however, required to prove the defendant's guilt beyond all doubt or to some mathematical certainty. A reasonable doubt means just what it says. It is a doubt based upon common sense and reason. It is the doubt of a fair-minded, impartial juror who is honestly seeking the truth. It is not a vague or arbitrary doubt. It is a doubt for which a reason can be given, and that reason arises from your consideration of the evidence, lack of evidence, or conflicts in the evidence. If, after considering all the evidence, your mind is wavering, unsettled, or unsatisfied, that is a doubt of the law, and you must acquit. But if such doubt does not exist as to the defendant's guilt, you would be authorized to convict. Evidence that merely places upon the defendant a grave suspicion of the crimes charged or merely raises a speculation or conjecture of the defendant's guilt is not sufficient to authorize a conviction. It is my responsibility to instruct you on the law, which is what I'm doing right now. You are bound by these instructions. It is your responsibility to determine the facts from the evidence presented. You must then apply the law I'm giving you to the facts that you find. You must decide this case based only on the evidence presented during trial. That's the whole no outside research part. The evidence that you've received consists of testimony and exhibits. Evidence does not include the indictment or plea of not guilty, anything I've said or the lawyers have said to include their opening and closing remarks, nor does evidence include any questions that were posed. It's only answers that are evidence. Evidence may be direct, circumstantial, or both. An example of direct evidence is the testimony of a person who asserts that she has actual knowledge of a fact, an eyewitness. I was there, here's what I saw. Circumstantial evidence is proof of one or more facts that tend to prove or disprove some other fact by inference. People walk into the courtroom, they have umbrellas, they're wet. You could infer that it's raining. That's circumstantial evidence that it's raining. But as we discussed yesterday, no windows in here, so this is a tornado-proof courtroom. There is no legal difference in the weight you may give to direct or circumstantial evidence. In considering the evidence in this case, you may use reasoning and common sense to make deductions and reach conclusions. However, you may convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the defendant's guilt beyond a reasonable doubt. You must determine the credibility or believability of the witnesses in this case. In deciding this, you may consider all the evidence, the witness's manner of testifying, their basis for knowing the things about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their possible bias for or against a party. The credibility of a witness may be attacked by disproving facts to which the witness testified. You may also consider other evidence offered to attack the credibility of witnesses, including evidence of a witness's bias for or against a party. If a witness's credibility has been attacked, you may consider evidence offered to support the credibility of that witness. Your assessment of a witness's credibility may also be affected by comparing that witness's testimony here at trial to statements that the witness made before trial. You must decide whether there is a reasonable explanation for any inconsistency between a witness's pretrial statements and trial testimony. You've heard from several witnesses who have been designated experts. Experts are those who, because of their training and experience, possess knowledge in a particular field that is typically not known to the average person. Experts are permitted to give their opinions based upon that training and experience. Testimony of an expert, like that of all witnesses, is to be given only the weight and credit you decide it is entitled to receive. The testimony of a single witness is sufficient to establish a fact. Corroboration of a witness is not required, provided you find the witness's testimony to be sufficient. Defendants who, as I have told you many times, have no burden to prove anything are not obligated to testify. When, as here, a defendant chooses not to testify, you may not consider that decision in any way in reaching your verdict. The state must prove the identity of the person who committed the crimes charged beyond a reasonable doubt. The defendant does not need to show that some other person committed the alleged crimes. And a crime occurs when the law is violated by a defendant's intentional action. Intent is an essential element of every crime. Criminal intent is not the intent to violate the law, but means simply the intent to do the thing that is illegal. Intent may be inferred from the evidence. It may also be inferred when it is the natural and necessary consequence of an act. The defendant is not presumed to have acted with criminal intent, but you may find this intent, or the absence of it, upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the acts for which the defendant is being prosecuted. If one intentionally commits an unlawful act, yet the act harmed a victim other than the one intended, it is not a defense that the defendant did not intend to harm the actual person injured. The defendant has raised the defense that even if he committed the acts described in the indictment, there are circumstances that justify it. Once this defense is raised, the state must disprove it beyond a reasonable doubt. Sometimes a defendant's use of force is legally justified and so is not a crime. A defendant is justified in using force that is intended or likely to cause death or serious bodily injury when, number one, he reasonably believes that the use of such force is necessary, and number two, he does so to prevent either death or serious bodily injury to himself or the commission of a forcible felony, which is a felony that involves the use of force or violence against another. Aggravated assault is a felony, a forcible felony, which I will define for you shortly. The state has the burden of proving beyond a reasonable doubt that the defendant's actions were not justified. If you decide that the defendant's actions were justified, it would be your duty to define the defendant not guilty. The defendant is not justified in using force if he provokes the threat or use of force against himself, intending to use that threat or force as an excuse to harm the other person. He is not justified if he is committing a felony. Aggravated assault is a felony, which, as promised, I will define to you shortly. And a defendant is not justified in using force if, it's really an or, so it's any one of these three, if he is the initial aggressor, unless he withdraws from the encounter and clearly communicates to the other person his intent to withdraw, and the other person continues or threatens to continue the use of unlawful force. Words alone never justify the use of deadly force, no matter how abusive or provoking. However, verbal threats accompanied by some menacing action may justify the use of deadly force. For the defendant's use of force to be justified, the defendant must believe that his use of force is necessary. That belief must be reasonable. That is, a reasonable person would also believe that the use of force is necessary, and the defendant's reasonable belief must be what prompts him to use the force. A person who is not the aggressor is not required to retreat before being justified in using force he reasonably believes to be necessary. We're more than halfway done. Criminal cases must be tried in the county in which the crimes were committed. This question of venue, that is, were the alleged crimes committed here in Fulton County, must be proved by the state beyond a reasonable doubt. Now we get to the substantive offenses. Murder. For murder, the state must prove that the defendant, number one, caused the death of another person. Number two, that he did so unlawfully, meaning not justified. And three, with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill without justification. You may find malice when the circumstances show that the defendant acted with deliberate intention to unlawfully take the life of another. You may also find malice when there does not appear to be significant provocation and the circumstances of the killing show an abandoned and malignant heart. And actually in the law, it says that. So I'm required to tell you what one way you can find malice. The state does not have to prove premeditation in order to prove murder. If a killing is done with malice, that is, with unlawful intent, it is a murder, regardless of how briefly that malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the killing and it moved him to do it, that is enough for the killing to be murder. Proof of motive is not an element. It is not essential to the crime of murder. Evidence of motive, if any, has been admitted for you to determine whether it establishes the defendant's state of mind at the time of the killing. Felony murder. For felony murder, the state must prove that the defendant, number one, caused the death of another person. Two, by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. And aggravated assault, which I promise I will define, is a felony. You may find a defendant guilty of felony murder if you believe that he caused the death of another by committing the felony of aggravated assault, regardless of whether he intended the death to occur. There must, however, be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death occurred. Aggravated assault. A person commits an assault when he attempts to commit a violent injury to another. A person commits aggravated assault when he assaults another with a deadly weapon. The state must prove as an essential element of aggravated assault, as it's charged in this case, that the assault was committed with a deadly weapon. And I instruct you that a firearm is a deadly weapon. And the last charge in the indictment, a person commits the offense of possession of a firearm during the commission of a felony when he possesses a firearm during the commission of a felony. Murder, felony murder, and aggravated assault are all felonies, and a firearm includes any handgun. You should consider each count in the indictment individually. The defendant may be found guilty of some, all, or none of these charges. If, after considering the evidence together with the charge I'm giving you, you should unanimously find, beyond a reasonable doubt, that the defendant did commit here in Fulton County any of the crimes alleged in the indictment, you would be authorized to find him guilty. In that event, the form of your verdict on this verdict form would be, we, the jury, find the defendant guilty. And in the blank next to guilty, you'd put a check mark. Here it says, write the word guilty. We've actually taken care of that for you. The words guilty and not guilty are provided for each of the counts. And you'll just check guilty if the conditions I just described are met. If you do not believe that the defendant is guilty of a particular offense, or if you have any reasonable doubt as to his guilt, then it would be your duty to acquit him, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. And in the blank on the verdict form for that particular offense, you would check not guilty. Whatever your verdict is for a particular count, it must be unanimous, meaning you all agree to it. Your verdict must also be in writing, signed by your foreperson, and dated. And the verdict form has a place for the date and the foreperson signature. By no ruling or comment that I have made during this trial have I intended to express any opinion about the credibility of the witnesses, the evidence, or the possible guilt of the defendant. Your verdict must be based solely upon your consideration of the evidence, according to the laws I'm giving you in this charge. It is your duty to consider the facts objectively, without favor, affection, or sympathy for anyone. It is also your duty to report to me if you perceive that a juror is making decisions based on improper considerations of race, gender, religion, or sexual orientation. You are the fact finders in this case. You are not to concern yourselves with punishment. That is a role for the judge. One of your first jobs in the jury room will be to select a foreperson who will preside over your deliberations and who will sign this verdict form to which all of you freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion of the case with your fellow jurors and a careful consideration of the evidence. During your deliberations, you must not communicate with anyone outside your group about this case, nor may you conduct any outside research. You have all the evidence there is in this case for you to have. It would be improper to supplement it with any outside information. To help ensure that that happens, Deputy Gordon will be collecting your electronic devices. We will hold on to them. I promise you'll get them back, but you'll get them back at the end of the day and not because you're curious and want to look something up. Finally, going forward, should you need to communicate with me for any reason, it needs to be in writing. Write down the question, the concern, the inquiry, whatever it is. And when I get your note, your question, I will confer with the lawyers and share with you whatever response I am allowed by law to give. You may have a great question and the law may be that I have to tell you, you have to rely on your recollection. Don't be annoyed with me. That's just the answer that I'm required to give depending on what the question is. But I will do my best to be as responsive as possible to the questions you may have, if you have any. And with that, you've received the charge. In a moment, I'm going to have you go back to the jury room. You will get all the evidence, this jury charge, this verdict form, and this indictment. But I need Ms. Smith and Mr. Maltzby to stay while the other 12 of you go to the jury room. Please.
All right, the jury.
You two are our alternate jurors. You are our safety valve. You all can be seated. You were our safety valve during the trial. Juror 27 could have popped at any point, and one of you then, you wouldn't have known it, but one of you would have moved into the group of 12. And we don't tell folks in advance, because if you told the alternate in advance, I'd just sleep through the trial. I mean, why would I be paying? I might be late. And, so you all have seen and heard everything everyone else heard. And you're going to stay here today while the jury deliberates. If they don't finish today, we can talk about whether one of you will come back or both, or if you could be on call, if you could be here quickly. But for today, will they be in the other jury room? You're going to get to be in the shelter. There's a bathroom there. That's your space. You get to keep your electronic devices if you brought them, but you may not research anything. And you two shouldn't talk about the case. Don't do your mini deliberations. Wait, what will we do? You can talk about anything else you want. You don't have to talk with each other, but you need to remain in that bubble you've kept yourself in, not learning about this case except for what goes on in court. If we lose a juror, one of you will join that group and they will restart their deliberations. You won't have missed anything. Actually, I will tell them, hey, you got to start over again. And they'll get you up to speed quickly, but they actually restart the deliberations. If we lose 2 jurors, then both of you will join. If we lose 3, bad things happen, but we're not there. We've got a good buffer here. It was key that you were here. You will stay here. I promise we won't forget about you. If there's a verdict, after we've received the verdict, we can bring you out. You'll get to hear what happens from there, but you won't be there over the weekend. Like, hey, do you remember us? So what I'm going to ask the 2 of you to do is get your stuff from the jury room, whatever you brought today, and then Deputy Gordon or his colleague will get you into that room, and then they'll be checking it on you from time to time, and we'll loop you in when it's appropriate to do so. Okay?
Sir.
Thank you. Ms. Ocom, any exceptions to the charge as given?
No, Judge.
Ms. Primovic, other than your request to have the literal pattern charge for prior statements, inconsistent statements, any exceptions?
Just one more, Your Honor, it was discussed way earlier, 131.45, witnesses impeached. There were 2 that you could do. You stated the credibility of a witness may be attacked by disproving the facts to which the witness testified, which I believe is on end of page 3. We discussed previously the first option to impeach a witness is to show that the witness is unworthy of belief. A witness.
You were saying?
Thank you, Your Honor. The first alternative to impeach a witness is to show the witness is unworthy of belief. The witness may be impeached by disproving the facts to which the witness is testified. That's
Okay. Both exceptions are noted, preserved, and we'll see where that goes. Where are we in terms of the evidence going to the jury? Do we have any disagreements that I need to referee?
I think we agree on everything, Judge. The only thing is there is a disc, and I know sometimes judges like to hold on to the disc, or some judges like to take the disc back.
I like to send the disc back because it reminds the jurors that that evidence is there. They've received a lot. And so if they see that disc, they may say, wait, I want to play that again. And they can ask that question. So as long as Deputy Gordon has concluded that the weapons are safe, I think everything that you all have agreed goes back should go back. And if you've decided certain things shouldn't, like the ME's report or something, then that doesn't go back. And I don't have to get in the middle of it. And Deputy Gordon, I'm gonna hand to you these three documents: indictment, verdict form, and jury charge. If you'll add that. Ms. Feely and Ms. Okam, I need one phone number to call for each side to get people back here. So if you two could write something down on a single piece of paper that you'll share, I will hold on to that.
So, Your Honor, on the record, we are not sending back 191, 198, and 145.
Okay, everything else is going back.
Yes, sir.
And you agree with that, Ms. Russell?
Yes, Judge.
Great. Okay. Deputy Gordon will get stuff back there. Deliberations are beginning at 2:43. I'm getting a phone number for the state, phone number for the defense, and we will reach out if you happen not to be in here when there's a question or verdict or whatever happens. I'm going to leave them alone until around 5 if we don't hear anything from them, and then we'll see how late they want to go tonight versus coming back on either Monday or Tuesday, and we'll take their pulse about dates as well. Anything else, Ms. Okam?
No, Judge.
Anything else, Ms. Feely? I want to thank both sides for the way they've approached this case. It is always helpful when both sides are organized and prepared. This went very smoothly for a case this old and a retrial. It's sometimes hard to find the record from before. It's particularly hard to find witnesses, but the state was always ready with witnesses. And I also want to commend both sides in the way that they interacted with each other. Cases can take longer and get much more unpleasant when the sides needlessly disagree with each other, and that didn't happen here. So thank you for that. And we will just be on standby until we hear something from the jury. I will mute the system in here so people can talk freely, and I'll unmute it when we come back on the record. All right, Ms. Rivers, are you ready? I'm not though, because we don't have any defense attorneys, criminal defense attorneys, nor do we have the defendant. But I can call, I've got the phone number.
Maris was just right here.
Marilyn is here.
Okay. It's just a question. It's a pretty low key. I mean, the question's interesting, but all we have is a question. Can I give you, sorry, this is Courts Exhibit 1. You guys getting your client?
Yes.
Chief? I'm well, sir. Yourself? Good. It's just a question. Half the opposite. Okay, and it's not a question of where is the bomb hidden, nothing like that, okay? But I'm glad you're all here. It's good to see everyone. We're just waiting on the defendant. You can be thinking about it. The question says, does self-defense negate aggravated assault? Out of the building? Okay. So you've managed, oh, there he is. So you get everyone except Mr. Beard.
He's a slow walker.
I understand. It's not a problem. Let's get back on the record, please. In State versus Beard, the jurors have presented their first question during deliberation. The question reads, does self-defense negate aggravated assault? And Mr. Beard, I shared the contents of the card with Ms. Feely as well as the prosecutors while you were working your way here, so they can already have an answer. Ms. Okam, what, if anything, do you think I should share with the jury?
Your Honor, the state's position is that that is already addressed in your jury instructions. I don't think you can give them an answer. I think the answer would be that you're giving them the law of which they need to follow, and they need to follow the law.
Okay, Ms. Feely.
And the answer is obviously yes. We've had case trials in which we've raised self-defense with just aggravated assault, aggravated battery. We could recharge them on self-defense and aggravated assault would be our request.
Okay, my thought, which maybe is, I guess, neither one of those, would be to write to them, if you find that the defendant acted in self-defense, that can be justification for what would be aggravated assault. Words to that effect. I think that's legally correct. I don't think I'm going to just say, read the jury charge again, or I've already answered that for you. Those weren't your exact words, Ms. Okam. I'm reluctant to bring everyone in and read the jury charge again. Not that there's anything wrong with it, just a big production. And I don't think I'm helping them reach any legal conclusion, especially by putting it in the conditional. If you find that the defendant acted in self-defense, then however I put it, I can pen something along the lines of what I said. I'll read you the draft. Do you have an objection to that approach, Ms. Feely? Ms. Okam?
No, Judge.
Okay, let me draft something and read it and then see what you say before what I was gonna do is write it on the card so we don't have to bring everyone out here. All right, what I propose to write on the back of the card is, if you find that the defendant acted in self-defense, comma, you could find that aggravated assault was justified. It's a little complicated because I don't want to say plural. They may be thinking one is and one isn't, so I'm leaving it general. You could find that aggravated assault was justified. Any issue with that, Ms. Feely? Ms. Okam? All right, let me write legibly here. All right, on the back of the card, I wrote, if you find that the defendant acted in self-defense, you could find that aggravated assault was justified. I initialed it and dated it. I'm going to have Deputy Gordon return this to the jurors. He hinted that they may have a couple more questions in the works, so please don't go far for a few minutes. If we get to 5:20 and you haven't heard from Deputy Gordon, you can go back to where you were. We've also asked the jurors to let us know how late they think they're going to go, because we need to let you all know and let the sheriff's office know how late we'd be keeping the building open tonight. And the answer will be some rule of reason. If they say all night, it can't go all night, and then we'll need to figure out, are they coming back Monday or Tuesday? Thank you. And we can go off the record now. I'm working on this list of names if people are coming on Monday. Volume back on. All right, we're back on. Question number 2. Can we find him, I assume that would be Mr. Beard, guilty of aggravated assault without finding him guilty of felony murder, even if the victim died? Can we find him guilty of aggravated assault without finding him guilty of felony murder, even if the victim died? The answer to that is yes. But I will listen to ideas that suggest the answer is something other than yes. And that's what I intend to write. Ms. Ocom, you want to think about it a little bit more? Ms. Feely?
Also thinking.
Okay. Do you need something super formal to go to the desks? If people are coming in on Monday, I have a list of the names from the 2 sides of civilians who'd want to come in. It's just a list and I'll sign it. That'll work. Okay. We'll do it. I'm listening. Anytime you want to say something.
Yes, Judge, sorry. Well, the state's position is it should say the defendant may be found guilty of some or none of the charges without saying yes or no. So.
Okay, I hear those words. I don't think that's responsive to the question, but I understand what this state is requesting. Ms. Feely.
We're fine with just answering the questions, and the answer legally is yes.
Okay, I believe the correct answer legally is yes. That's not inconsistent with what you're suggesting, but they didn't ask me to repeat a sentence from the jury charge. So I'm going to write the word yes. Deputy Gordon will deliver it, and no one should leave for a few minutes.